Good morning. Welcome to the Marion County Board of Commissioners meeting. It's Wednesday, June 20th, 2018. We're in the Senator Hearing Room at Courthouse Square in Salem, Oregon. We'll begin our meeting with the Pledge of Allegiance and invite you to join us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we are having a business meeting here between 8 and 8:30. Between 8:30 and 9. It's already 8:30. And the public hearing that on the land use case is noticed at 9 o'clock. So even if we get done a little bit early with the business meeting, we can't begin that public hearing until 9 because that's when the public notice went out. So those of you that are here for that will have a chance to see your Board of Commissioners in action. So it will be a lot of fun. So the first item that we have on our agenda is public comment. We had several people that signed up for the land use case under public comment, but that will come later. So we only have one person that's actually signed up on another topic. Looks like V.A. Vanderhyde from Twin Fir. Yes, if you'd like to come over here and make your comments.
And over here is where?
Right over there.
Ah, okay. Good morning, ladies and gentlemen. Thank you very much. My name is Vincent Vanderhyde, and I am here to make a kind of a discreet inquiry into the status of the investigation into the incident involving a deputy sheriff and a citizen over in the park. Is there any further information as to when that investigation will be available, terminated? More information available on that.
We had the sheriff here last week, and he commented that, it's really under his jurisdiction. He is doing, I think it's a review, and then an internal review, and then they determine whether an investigation is in order. The investigation will be done by an outside party. So, Jane, you may have more information on what the status is of that right now.
Madam Chair, I think you summarized.
Green light needs to be on.
I believe you summarized it accurately. It's still under review. And they are working on it.
Okay, so she said
Okay,
it's still under
didn't hear
review.
that.
So she didn't have any specifics in terms of the time frame.
Okay. I must say that having watched the video that's available on the internet of a Marion County deputy sheriff, that is to say 4 of them, I gather, and one of them striking this individual, by my count, at least 16 times as he was laying on the ground, is certainly a worthy of a serious investigation and serious consequences for the officer and officers that participated in that behavior. That does not meet, in my opinion, the standard of behavior and conduct that we expect from police services in Marion County. Thank you.
Thank you.
Thank you.
I would add, obviously, we're not commenting because as a board, we're not commenting until the investigation is complete. But I know that the sheriff has commented in press releases and in public that he is definitely taking it seriously. So, anyone else that came for public comment, not land use hearing, but public comment on a topic other than the land use hearing? All right. So we will move into our consent agenda, which Commissioner Brentano gets the privilege of reading. It's very long today because we wanted to keep this meeting to a half an hour. So anything that could go on consent went on consent, and there's quite a long list. So, Commissioner?
Madam Chair, if I could, I'd make a motion to approve our consent calendar this morning. On it or in it is under Board of Commissioners, all C applications with recommended approval. Salem Gas and Grocery DBA, Salem Oil LLC in Salem, Oregon. Las Cazuelas, you could probably do that better than me, in Salem, Oregon. Business Services, approve an order revising the Retirement Plans Committee Charter. Community Services, approve an order awarding the fiscal year 2017-18 business development grant application to Metal Tech Cage LLC in the amount of $50,000. Approve an order awarding the fiscal year 2017 to 18 community project grant applications to the following: City of Almsville, $10,000; City of Mont Angel, $16,000; City of Turner, $15,000; City of Woodburn, $15,000. Finance, approve a quitclaim deed to convey real property tax ID R23783 and manufactured home ID M130372 located at 402 63rd Avenue Northeast in Salem to the prior owner of record. Health, approve the incoming intergovernmental agreement with Oregon Health Authority for $1,140,000 to provide Medicaid administrative claiming services for children and families served by the county. Information technology, approve the client support and software update services agreement with Tyler Technologies Incorporated for $179,340.61 to provide service and support for the assessor's office, tax office. For this, anyway. Public Works. Receive notice of a hearings officer decision approving conditional use case 18011 Marion SSD 4 LLC on property owned by Selkirk Holdings LLC. Receive notice of hearings officer's decision approving a conditional use case 18010 Marion SSD 6 LLC on property owned by Gabriel and Vasa Malodi. Sheriff's Office, approve an order appointing Cindy Lineser, Dan Clem, Tina Morris to the Marion County Justice Reinvestment Council with terms ending December 31st, 2018. Approve the intergovernmental agreement with Jefferson Patrol Services for $342,963 to provide law enforcement services to the city of Jefferson. Approve the intergovernmental agreement with Marion County Community Service for $131,400 to provide work crews for the dog shelter. Approve Amendment 1 to the contract for services with Bridgeway Recovery Services for $338,722 to add funding for the jail reentry cognitive and treatment courses. And the last, approve Amendment 1 to the contract for services with Chemeketa Community College for $383,280 to add funding for the source services for clients of the Parole and Probation Division.
And I'll second the motion.
Okay, we have a motion and a second of all of those items. Any comment on any item? Did pretty well with the names, Commissioner.
Couple
Yeah, a
trips.
couple were on the edge, but that was pretty good. All right, if there's no further discussion, all in favor of approving those items, say aye.
Aye.
Aye,
Aye.
and they're all approved. Thank you. So we have just 3 action items. The first is under Community Services. It's to consider the second reading and adoption of an ordinance allowing property tax exemptions for eligible brownfield cleanup projects. And we have Tom Hogue from Community Services and Scott Norris from our legal department. Good morning, gentlemen.
Good morning, Commissioners. For the record, I'm Tom Hope, Community Services Department Economic Development Coordinator. We have second readings on 2 ordinances today granting tax exemptions for different purposes. This first one is for last resort funding of brownfield cleanup projects. In this case, an owner of a property that has a legacy brownfield not caused by the current owner could apply through the assessor's office for property tax relief in order to fund that cleanup effort. It allows for a property tax exemption of up to 10 years or the total amount of the approved cleanup plan. I think that's a good summary. I'll turn to Scott for about the second reading information.
Good morning, Commissioners. My name is Scott Norris from the Office of Legal Counsel. As you mentioned, this is the second reading of this ordinance. This ordinance is being adopted under the regular procedure for adoption of ordinances. After the second reading today, the board may move to adopt the ordinance, and if it does so, the ordinance would then take effect 90 days from today. And if there are any questions, we'd be happy to answer them.
Any questions? So this came before the board 2 weeks ago with a lengthier presentation on the content of it. As you mentioned, it is allowing a property tax exemption for brownfield property cleanup. And this is for private parties, right, to do brownfield
Yeah.
cleanup?
Yeah,
Yes,
Madam Chair,
Commissioner.
just to clarify, and Tom, I just want to make sure, they would still have to get the 75% taxing districts to sign off for this.
Yes, so the applicant would go to the assessor's office, who would then forward a board order to the commissioners for approval, and then the applicant would seek approval of at least 75% of other affected taxing districts, and it would be their responsibility to do that.
So I just want to clarify, this isn't an automatic thing. There's some
It's
hoops
not an
we have to
automatic
go
thing.
through, so, great. Need a motion?
Yes.
Madam Chair, I'll move that we approve second reading and adoption of an ordinance allowing property tax exemption for eligible brownfield cleanup projects.
And before we second it, we don't need to read it by title if we're doing a second reading, is that right? We just approve it, right? So,
I'll second it.
okay, so we have a motion and a second to approve the ordinance. Any further discussion? All in favor of the motion, say aye.
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 All right, that's approved. Thank you.
Thank you.
And then
This-
we have a second reading now of another ordinance that we also heard 2 weeks ago, and this is adoption of an ordinance allowing a property tax exemption for rural industrial investments. And we have the same people, Tom Hoag, Scott Norris. So Tom?
So again, Tom Hoag, for the record, Tom Hoag, Community Services Department. Cities throughout the state of Oregon have a sort of an economic development incentive tool called an enterprise zone that allows new investments to receive a property tax exemption benefit, but that's not generally available outside of cities. In 2016, the legislature approved a new program, and it was amended in 2018 to clarify some language. Now it can be applied in rural areas outside of UGBs of 40,000 people or more. So in Marion County, that's everything outside of the Salem-Kaiser UGB, I believe. In that area, Marion County is initiating this ordinance, and so in rural unincorporated areas, an applicant can come again to the assessor's office with an application for if they're making investments of $1 million to $25 million, new investments, and then receive a tax exemption for up to 3 years, as an incentive to make those investments in rural areas, and that was the intent of the legislation. Again, this is not an automatic exemption. In that case, a concurring board order from the Board of Commissioners, and then the applicant would again go to the other taxing districts and seek concurrence, and then return to the assessor, and that exemption would take place. Again, on second reading, I'll turn to Scott.
And as I'd simply repeat at this point, this, like the brownfield ordinance, this is being adopted by regular procedure. This is the second reading of the ordinance, and upon approval of the ordinance here at the second reading, it will take effect 90 days from today.
All right. Questions?
No.
Madam Chair, I'd make a motion to approve the second reading and adoption of an ordinance allowing property tax exemptions for rural industrial investments.
I'll second the motion.
Okay, there's been a motion and a second. And just as a matter of note for people who might be listening, there is a Senate bill that passed that allowed us to do that. So we're doing this under the auspices of legislative authority. So no further discussion. All in favor, say aye.
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 All right, that's approved. Thank you.
Thank you, Commissioner.
Good job. It's been a long haul.
One more item, and that is under Public Works, and that's to receive and consider appeal of a hearings officer's decision dismissing the appeal of adjustment case number 17-002, Mid-Valley Community Action Agency, Inc. And Joe Fenimore.
Good morning, Commissioners. For the record, Joe Fenimore. This item before you today is an adjustment to allow a gravel surface driveway and parking area for a Head Start facility on a 5-acre parcel in a public zone located on Silverton Road Northeast in Salem. On September 20th, 2017, the Planning Director issued a decision approving the request. On October 5th, that decision was appealed to the Marion County Hearings Officer. After that appeal was filed, the applicant granted an extension to the 120-day decision-making deadline to try and work out a compromise with the appellant. When no compromise could be reached, the hearings officer conducted a public hearing on May 23rd. The appellant failed to appear at the hearing, and under the hearings officer procedural rules, if a planning director's decision granting a land use application is appealed and the appellant fails to appear at the hearing, the appeal may be dismissed. On May 25th, the hearings officer issued an order dismissing the appeal and reinstating the planning director's decision granting the request. On June 8th, that decision was appealed to you, the Board of Commissioners. In the appeal to you, the appellant states that they were unavoidably missed the hearing on May 23rd due to being out of state. They indicate the appeal is based on an incomplete inspection summary for a driveway access permit, not meeting the standards for temporary and seasonal gravel parking and loading areas, and they state they feel their health is at risk from dust and fumes generated from the gravel surfaces. The board has the options of accepting the appeal and remanding the matter back to the hearings officer, accept the appeal and schedule a public hearing with a suggested hearing date of July 12th, deny the appeal and uphold the hearings officer's decision dismissing the appeal and reinstating the planning director's decision granting the request. Staff recommends option 3, that the board deny the appeal and uphold the hearings officer's decision. I'll be happy to answer any questions.
Yeah, I just have a couple of questions before we open it up for the commissioners. So the appellant, the person who missed the hearing, said he lives out of state and he unavoidably could not attend the hearing. How was he notified of the hearing? Was it by mail, certified mail?
It was by mail.
Okay. And did he say that he didn't receive notice of it?
He did not.
He did not receive notice of
He
the
did
hearing?
not say that in the appeal, no.
Oh, he didn't say that, all right. And he didn't give anyone any communication prior to the hearing that he would not be able to attend?
Correct.
Okay. But it's just by regular mail, not certified mail?
Yes.
That he gets that, okay. All right. Any other questions? No? Okay. So what is the will of the board? What motion would, let's see, Commissioner Cameron, I think it's your turn.
Well, I see what staff is recommending, so I would probably go with the staff recommendation. The only thing I guess I would like to know, if the appellate is not here today, he hasn't written anything about this.
Correct. The only thing was in your packet.
Yeah,
So he's written a letter
yeah.
that's in the packet. But I don't think, if I could just add to, the content in the letter is not different than what the issues were that were heard in the
Right.
hearings officer's
Correct.
review, right?
So, Madam Chair, I will make a motion that we consider the appealing officer's decision dismissing the appeal of adjustment case number 17-002 Mid-Valley Action, Community Action Agency, Inc.
So we're going to deny the appeal, is that what you were
Yes.
saying? All right, okay. Is there a second to deny the appeal?
When did it capture it all and dismissing, reinstating the decision, is all that implied in the motion?
Oh, wait.
So it would be option 3 on the,
Well, let me withdraw my motion.
You wanna restate it?
Withdraw my motion and have a little more discussion here. Well, because legal counsel just said that in the letter, they said they were not notified,
Oh.
and I didn't see that.
I didn't either.
Where do you see that?
I'm looking, it says, we were never mailed any project notification letter prior to this letter. On Friday, September 22nd, we received a letter of notice of decision. We phoned Marion County to inquire why we were just now being notified after the fact. So I guess that doesn't mean they didn't get the decision, but it's not super clear.
Correct. I think what they were saying, they never got notice of the 180-day extension that we granted. That the applicant granted additional time to try to work out a compromise, additional 180 days, and they were not, and the appellant was not notified of that, but that's nothing we're required to notice on.
Okay.
Okay.
so
All right,
then,
so it wasn't about the original. Okay.
Correct. And also, one point, the case number is actually 17003 instead of 2.
okay.
All right, Madam Chair, let me make a motion to,
Let's do it off of option 3 on the options for consideration, then I'll have everything
yeah,
right there.
Madam Chair, I'll move that we deny the appeal, thereby upholding the hearings officer decision dismissing the appeal and reinstating the planning director's decision granting the request.
Does that work for you?
Maybe add that in case 17003, just to be clear.
Case number 17-003, Mid-Valley Community Action Agency.
And I'll second it.
All right, we have a motion and a second to do option 3, which is to deny the appeal, uphold the hearings officer's decision dismissing the appeal, and reinstating the planning director's decision granting the request. Any further discussion? All in favor of the motion, say aye.
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 All right, that's approved.
Thank you.
All right, it's just a few minutes before 9 o'clock, and as I mentioned at the outset, we will not start until 9 o'clock. I think what I will do is read the Wednesday to Wednesday calendar. Sharon, you want to switch over to the end of the meeting? And then we won't be needing to do that after the hearing.
He's got thumbs up.
Okay, so on Thursday, tomorrow, these are meetings where 2 or 3 commissioners will be present between June 20th and June 27th, 2018. And we've noticed today we're in a board session starting at 8:30. It's June 20th here at the Senator Hearing Room. Tomorrow, June 21st, Thursday at 8 a.m. is the City of Salem, Marion County meeting at the Sassy Onion Grill on 1244 State Street in Salem. Monday, June 25th at 8:30, we have our weekly calendar review. That's held in the Silverton Conference Room upstairs, 5th floor, here in Courthouse Square, 555 Court Street, Northeast in Salem. That's followed by 9 a.m. by management update, same place, Silverton Conference Room. Still on Monday, June 25th at 2 o'clock is a Marion County Public Safety Coordinating Council planning meeting, also in the Silverton Conference Room. June 26th, Tuesday at 8:30 is a meeting of the Community Corrections Board, also held in the Silverton Conference Room. That will be followed at 10:30 by a meeting of the Marion County Housing Authority Board, also in the Silverton Conference Room. And then at noon on June 26th is a meeting of the Marion County Public Safety Coordinating Council Steering Committee in the Silverton Conference Room. Then still on Tuesday, June 26th at 3 o'clock is the Mid-Valley Behavioral Care Network Budget Committee and Board of Directors meeting. That will be held in the large conference room over at the Behavioral Care Network offices, 550 Hawthorne Avenue Southeast, Suite 140 in Salem. Then next Wednesday, June 27th at 9 a.m., we will be back to our regular time, and we'll be here in the Senator Hearing Room for our regular Wednesday board session. And then maybe I can just go through the procedures before we actually start the hearing. Is that going to be all right?
Absolutely.
So first of all, thank you all for being here. This is larger than the usual crowd that we have at our board meetings, and so we're going to exercise some procedural rules that we haven't had to use very often, because most of the time we just have 1 or 2 people that are here coming to comment on land use topics. So the first one would be, please silence your cell phones. I've already heard a couple of them going off as we were in the other part of our meeting, so make sure it's either off or on vibrate or silent or whatever. Secondly, we are going to impose time limits today because we have so many people that have signed up. Staff will get 10 minutes to present. The applicant gets 15 minutes to present. And then there will be, we will take, hopefully, the proponents, the people who are in favor of the application first. And we won't always get these in order because sometimes people don't always check the box, but we will try to do that. And everyone will get 3 minutes. So you'll need to limit your comments to 3 minutes. Christy, our board clerk, Christy Witherow, will be keeping time. And so then she will actually announce when the 3 minutes are up. And then when the 3 minutes are up, you don't have to stop in mid-sentence, just complete your thought. Although completing your thought doesn't mean an additional 3 minutes, all right? It means within reason. And the commissioners do have the option to ask questions. If we don't have any questions, we will say we have no questions, and then we will move on to the next person who wants to testify. I would encourage everyone to stay on topic. This is a hearing where actually the planning staff, Brandon will go through all of the details of it, have already presented a report on the mass gathering aspect of this, and then our hearings officer has actually reviewed the conditional use part of this. They've actually said that a number of things have been, what's the word I'm looking for?
not satisfied.
Satisfied,
criteria not
thank
met.
you. Number of items have been satisfied, but there are several that have not, and so we're really going to pretty much hone in on those items that have not been satisfied. I know that there are folks that have passionate views on this, pro and con, and so if you want to express those, great, but your testimony will be most effective if you're really sticking to the issues that the commissioners are needing to weigh in on. Civility is a wonderful thing. Hopefully, people will keep their language clean, that you will not be pointing fingers at each other. Just stick to the topic at hand. No clapping, please. If you agree with someone, you can, about nodding your head would be great, but really, we're trying to keep a decorum in here, and so we really would appreciate it if there isn't clapping, calling out. You get one bite at the apple also, so if you come up in your 3 minutes and then you think of something else and you raise your hand and you say, I want to say this, I'm sorry, you can't do that. So just make sure that you say what you have to say within the 3 minutes that you have. And what else? I think that's everything. Is there anything I've left out? Jane?
No, it's just, I would say that the code limit, or the time limits is authorized by our code 2.4.
Thank you. And I have a copy of the code here with a cheat sheet about what it says, so. Commissioners, anything you want to say before we
After you
start?
open it, I'd like to start with 2 minutes.
You want, well, it's not on my list that
I
you
know.
get 2
Yeah,
minutes. All right, we'll add that in. I don't, do you
Commissioner's
see it on
prerogative.
the code?
Yeah, is that in the code that Sam can talk for 2 minutes?
I believe Commissioner Brentano has something he needs to tell the board.
Yes, I remember this now. You mentioned that to me yesterday. All right, so we will do that.
Is it something about your birthday?
No, it's not about his birthday.
I wish.
So we have 3 minutes.
All right.
When's yours, John? This week? Happy birthday.
Jan's is Sunday.
And that was just a
Another year
coincidence,
younger.
yeah. But they're the same zodiac sign.
Yes, I was chastised, it's a great deal.
Okay. So my clock says we've got 2 minutes before we start. It's a very quiet group. And also, I think we want to announce that we have a gentleman on the phone, is that right? And are you going to announce?
James Bukal is on the phone.
Okay.
He's representing some opponents.
Okay.
He is from, he's overseas, and so we arranged a method to get him
Okay.
involved.
Excellent. Well, hopefully, he's not paying overseas rates for this call. Just saying. When I went to Europe, they told me not to keep my Sprint phone. Because it's really expensive. Okay, got it. All right, it's 9 o'clock. We will open a public hearing to consider the application for mass gathering case number 17004. This is the correct number, right, Brandon?
Yes.
Noise variance number 17001, and conditional use 17043. And this is for Willamette Country Music Concerts LLC. So before we open it up for staff for 10 minutes, Commissioner Brentano, you get 2.
I don't think I'll need to. I just wanted to put on the record, I had a conversation I wish I wouldn't have had, not understanding procedure. On April 13th, I met with Lynn County Commissioner Roger Nyquist to talk about transportation issues, and the subject of today's matter came up. So for the record, what he told me, what he's concerned about with their experience in Lynn County was traffic congestion, public safety, police and emergency services, alcohol distribution questions, slow cleanup of the subject and adjacent properties, and that he believes that the venue belongs at a place like resorts and stadiums designed for handling crowds. So it's nothing to disqualify my participation, but I want to make sure the applicants had the opportunity to address the concerns. So that's my 2 minutes.
All right, thank you.
And-
Anyone else want to declare any ex parte or conflicts or anything? All right,
Well, I
Yes.
did attend the Jefferson, I attended a Jefferson neighborhood meeting that they had, I don't know, 4 or 5 months ago in the fire station down there, and listened to presentation and at that time. So that would be something that neither of the two of you were there.
okay.
So I had that
Is there
information.
anything about that that would disqualify you today from
No,
participating in this
no.
hearing or bias your opinion?
No.
All right, thank you. All right, so Christie, you're going to start the timer, and Brandon, Reich, thank you for being here this morning.
Good morning, Commissioners. For the record, I am Brandon Reich, staff representing the Planning Division of Public Works. The item before you is the consideration of Willamette Country Music Concerts LLC for a large mass gathering permit on exclusive farm use zone property located at 13054 Jorgensen Road South, Jefferson. And as I go through here, if you have questions, please interrupt me, let me know, and we can discuss those as I hit different points, or we can discuss them at the end, whenever you prefer. Present today are staff representing county departments and the Jefferson Fire District, I believe. Cindy Schmidt, County Engineer. Greg DeBlaze, Marion County Environmental Health. Lieutenant Jerry Adcock, Marion County Sheriff's Office is here. I believe Tammy Robbins may be here with the Jefferson Fire District. She is. So if there's questions about the mass gathering aspects of different agencies reviewed, we have representatives here that can answer questions. The subject property consists of 12 tax lots on the north and south side of Wintel Road and the north and south side of Talbot Road, all west of Interstate Highway 5. The total acreage is approximately 720 acres. The properties are designated primary ag in the Marion County Comp Plan and zoned EFU. The applicant is proposing a music festival that would take place over 3 days, August 15th through 18th, maybe 4 days, 2019. Estimated attendance is 30,000 people. Based on this information, the proposed event meets the definition of a large gathering. According to the information submitted with the application, sound amplification will be used, alcohol will be available, and fireworks will not be used or shown. Staff recommends that a noise variance be approved for the use of sound amplification from 7 a.m. to 9 a.m. each morning if the mass gathering is approved. The mass gathering ordinance requires the applicant to coordinate with various governmental agencies to assure there are adequate facilities and services available. These agencies include Marion County Public Works, the Sheriff, Environmental Health, Risk Management, and the local fire district, which in this case is Jefferson, as well as in this case, the Oregon Department of Transportation and Oregon Water Resources. Each of these agencies was provided with a copy of the request and given an opportunity to comment on the requirements. The Sheriff and Fire District approved the plans. Public Works and Environmental Health provided conditions of approval. Public Works notes that the applicants have not received approval for a transportation impact analysis or a traffic control plan, but Public Works staff continues to work with the applicant on these plans toward approval if possible. An Oregon Department of Transportation and Oregon Water Resources will require permits be approved prior to the date of the event. Because the event is a large gathering, the event must also receive conditional use approval. In November, the board adopted an order which elected to consider the conditional use and mass gathering permits at one hearing today, calling up the conditional use for consideration and directing the Marion County Hearings Officer to hold a hearing on the conditional use application and make a recommendation to the board. The Hearings Officer held a hearing on December 20th, 2017 and February 21st, 2018. On June 7th, 2018, the Hearings Officer issued a recommendation to the board to deny the conditional use application. Her recommendation found that the county has the authority to define a large mass gathering to include the conditional use criteria, but that the board does not have the authority to grant a conditional use or a temporary use of the zone pursuant to ORS 215, the farm chapter of statute. In the alternative, if the board found it has the authority, as discussed in the Hearings Officer's recommendation, that authority would likely come from ORS 433, mass gathering statute. The hearings officer determined that even if the board does have jurisdiction to grant a conditional use or a temporary use, the applicant still hasn't met all of the criteria. Specifically, the hearings officer found that more likely than not, that the large-scale music festival in August would force significant changes in the accepted farm practices on surrounding lands devoted to farm use and increase the cost of farming. The hearings officer found that there was insufficient evidence to address whether the groundwater is adequately protected in the proposal, since the area is in a sensitive groundwater overlay zone. Also, approval of the application without additional input from the U.S. Fish and Wildlife is premature, unless and until it is established that there will be no significant adverse impact on the refuge, Ankeny Wildlife Refuge. There is a conflict with the Oregon Statewide Planning Goal 5, Oregon Open Spaces, Scenic and Historic Areas, and Natural Resources. The hearings officer found that it is not evident that any noise associated with the use will not have a significant impact on nearby uses, specifically on the Ankeny National Wildlife Refuge. Since the hearings officer determined that the board does not have the authority to grant a conditional use or a temporary use, or if the board determines that it has the authority, the gathering does not satisfy the criteria for a conditional use, regardless. Planning staff must recommend denial of the mass gathering permit because approval of the conditional use is required before the mass gathering permit can be approved. In addition, the applicant should be advised that because the hearings officer determined that ORS 433 applies, the criteria in statute 433-763-1CB must be met. The proposed gathering is, first, compatible with existing land uses, and two, would not materially alter the stability of the overall land use pattern of the area. Finally, mass gatherings may not include permanent structures. The applicant proposes to install a well for potable water on the site and an underground distribution system for the water. Based on the evidence in the record, it appears that the well and distribution system are being installed solely for potable water for the event. Because no permanent structures are permitted in conjunction with a mass gathering, the event does not meet the definition of a mass gathering, and the permit should be denied. Staff recommends the board receive the hearings officer's recommendation into the record today. And because so many of the public comments submitted on one case pertain to aspects of the other two cases, staff recommends the board enter the records of each of the cases, mass gathering 17-4, noise variance 17-1, and conditional use 17-43. Each of the cases enter the records into each other's. And with that, I'm available for any questions you may have.
Thank you, Brandon. Are there questions?
Not at this time.
No, I'll need some help with what you're describing if we get to that point.
I have a few questions, so just to get us started, kind of set the context. So as you mentioned, this is a mass gathering hearing. It sounds like there's a noise variance request, and then it's a conditional use hearing, all rolled up into one.
Correct.
So on the mass gathering, when I read through the report and you mentioned this, it seemed like everything in the mass gathering could be conditioned or was satisfied except for the permanent structure piece. Is that correct?
That and the receiving the conditional use approval, those two
Right,
aspects.
and the conditional use approval, obviously.
Correct.
All right, so would you comment again on the permanent structure piece? So, because we ran into this just last week, where there was a discussion about whether for the Renaissance Fair, their structures were permanent or not. She testified that they weren't. A neighbor was suggesting that they were. So what is the rationale in our mass gathering code or whatever for not allowing permanent structures? Does that come from state statute? Is that something that was figured out by the board when we designed that probably
It is.
10 plus years ago, or how does
It is
that work?
it is from state statute.
It is from state
ORS
statute.
433 prohibits permanent structures associated with a mass gathering. They're
Okay.
supposed to be temporary. So our code is consistent with that requirement.
All right, so this is not something the board has discretion over. This is something that is aligned with the state law.
Correct.
All right, great. Wanted to clarify that. And then under the conditional use, it seems like there are a couple kind of pivotal issues that are in this, and I'm sure that the folks testifying will get to this. But it seems like there was an argument that was being made that having a conditional use requirement as part of the mass gathering was not kosher, appropriate, constitutional, whatever word you want to use. So can you speak to how we ended up connecting a conditional use with a large mass gathering? And again, is that standard? Did it come from statute? What was the thinking behind that?
Oregon Revised Statute 433763 says that when you've got more than 3,000 people, more than 120 hours to take place, it becomes, it acquires the aspects of land use. So there's a land use component when it becomes that large. And so our code is consistent with that. When it becomes a certain size, a number of people, it has a land use component. And the county enacts or mythologize that land use component through the conditional use process, so that we have a chance to look at the impacts on surrounding land.
Okay. And then the second part of it then is that even, and I think this is what you were getting at in your comments, that when you were summarizing the hearings officer's report, so then even if we were to determine that on the conditional use side of it, that we didn't need a conditional use. No, that's not what I wanted to say. The second part of it is that the conditional use is not allowed in EFU. So a large mass gathering, I guess what I was reading, by its very nature, over 3,000 people is going to be found to be contrary to farming, right? I mean, she went through like a list of things that were allowed as conditional uses, and mass gathering was not listed in that list.
That's
So
correct.
can you kind of elaborate a bit more on that so we understand what the hearings officer was getting at when she talked about that?
Sure. So uses are authorized in the farm zones by state law, and most of them come out of ORS Statute 215, which provides a long list. Occasionally, there are some other areas that appear to authorize uses, like ORS 195 or some of maybe the park statutes. The ORS 433 regards mass gatherings and permits counties to adopt mass gathering regulations. And so those are not specifically part of the farm zone, but they're authorized by state law still. And that's why we have a mass gathering ordinance, to enact the county's authority under ORS 433.
Okay, but what I was reading in the hearings officer's report, and I just want to make sure that I'm understanding it correctly, is that up to 3,000 people, we could make that decision, but once it bumps over 3,000 within the farm zone, it just inherently is not, it's going to be contrary to acceptable uses within a farm zone.
Once it becomes over 3,000, then there's the land use component to look at the compatibility with surrounding uses and the ability of the use to be supported by the land that it's on. It doesn't require some kind of a service that the land itself can't provide.
Okay. I'm going to find the part that I was reading, see if, here it is. Okay, so I think it's on page 19, 20, 21, 22. There's a long list of things. And then on page 23, she writes, the only arguably relevant or similar conditional use in the EFU zone is agritourism events and activities excluding events that promote the use or sale of marijuana products or extracts, subject to the requirements of the code. And then it goes on, but it says the proposed use can't be considered agritourism. It says it doesn't provide any other catch-all provision that would allow the proposed use if it met certain other criteria. So it felt like that what she was saying is that this doesn't fall within any parameters of things. It's not a commercial use in conjunction with farm use. It's not agritourism. It's not any of these other things that we generally allow. So that's where I was wanting some clarity on that. Does that make sense?
Yes, so
All right.
so the hearings officer found that ORS 215 does not authorize the county to permit mass gatherings. And in her report, she says, however, if the board found that the county has the authority to permit mass gatherings, the board may find that. And there may be an avenue for the board to consider that.
So can you
through
explain that?
ORS 433.
So what would be the avenue?
It's through ORS 433, the mass gathering.
Which is the mass gathering statute?
So it's separate from ORS 215.
Okay.
So
But
the hearings
but the
officer-
legislature didn't reconcile the two, that in terms of the farming chapter and the mass gathering chapter?
They are separate, and they are separate authorizations under law, as I understand it.
Okay,
What's authorized under 215 and what's under 433 are separate authorizations.
all right.
The
Well,
LCD
well, I'm hoping that the attorneys for both sides have heard my question, and I'm sure that they will speak to it from their points of view. And then we'll
DLCD
be-
has guidance that says events over 3,000 people are land use, do have a land use component. And so
All right.
they recognize it that way.
Okay, but then it sounds like,
And the authorities from ORS 433.
okay, all right. It just sounded when I read the report like it was just kind of in a catch-22 situation, and there really wasn't a way that the board could find that, that a mass gathering larger than 3,000 people was compatible with farm use. So that was how I read it.
So I have information about a route through ORS 433 that I can provide to the board, and we can discuss it too if
Okay,
you want.
all right, let's not do that now, but let's keep that. And I want to hear from everyone about what they think about it, so. All right, any other questions? Okay, so now we have the applicant gets 15 minutes, and we have, let's see. Is it Mike Reeder? And then did you want, if you would come over here, you're going to be picked up by the camera better if you're over there, thank you. And then, did you have anyone with you that you wanted to present at this point, or not?
They have signed up to speak separately.
Okay,
Yeah, I'll be
Great, thank
taking 15 minutes. It's going to be a difficult task to get through all of the threshold legal issues, so I would appreciate, Madam Chair and Commissioners, if you have questions, please ask. Because
well, our questions will be outside of your 15 minutes.
Great.
So if you want to take your 15 minutes and present, and then we can interchange, and there is no time limit on questions.
Great, thank you.
Right.
Madam Chair, my name is Mike Reeder. I'm an attorney representing the Willamette Country Music Concerts LLC, who is the organizer of the Willamette Country Music Festival. It has been in Lynn County for the last 10 years. We are seeking to relocate to southern Marion County, and that's why we're here before you today. By way of background, I'm an attorney in private practice, formerly worked for the City of Ashland on land use and other constitutional issues for the City of Ashland. I represent farmers, ranchers, winery owners, and vineyard owners throughout the state. I have been retained by the applicant in this particular case because they were advised that they needed an attorney to represent them in front of the hearings official. So I represented the client in front of the hearings official, as well as here before you today. What I'd like to do is I'd like to talk briefly about the hearings official's recommendation to you and talk about some of the threshold legal issues that you're struggling with right now. Please understand that I've spent a significant amount of time responding to the very issues, the legal threshold issues that you're discussing right now. And I've provided you some written testimony that you should have in the record, and I'm here to clarify some of those issues. First of all, in 1970-71, the Oregon legislature dealt with issues of unregulated mass gatherings, rock concerts. One was the Vortex, Woodstock-like festival. And what happened is the Oregon legislature decided, as did many other communities and states throughout the nation, to regulate unregulated outdoor mass gatherings. And they did so under the police power authority. So in other words, what they needed to do was to enact legislation that would provide health and safety regulations that are reasonable time, place, and manner regulations that wouldn't offend free speech and freedom of assembly. And in the 1971 legislature, the ACLU actually came out in opposition to the outdoor mass gathering statute and said, this offends the Constitution. Years later, decades later, the Ninth Circuit Court of Appeals has upheld Oregon's outdoor mass gathering statute as facially constitutional. So what I'd like to do is explain to you Oregon's outdoor mass gathering statute, ORS 433, because if we start right, we'll go right. And so ORS 433 is Oregon's Outdoor Mass Gathering Act. And what it does is it creates two types of gatherings. It defines an outdoor mass gathering as 3,000 or more people gathered for more than a 24-hour period, up to 120 hours, mostly out of doors. What it does not do is it does not prohibit permanent structures, as been advanced by the opponents, as has been discussed by the hearings official and Mr. Reich this morning. What the ORS 433 says is that the outdoor mass gathering permit itself does not authorize permanent structures that would otherwise require land use approval. So the issue of the well that has been raised is a non-issue for two reasons. One is because the statute doesn't say what the opponents say it does, and two, because the application is not dependent on the well. If the commissioners were to decide that they couldn't use the well, the applicant would be able to move forward with the mass gathering without having to use the well. It makes no sense not to use the well. It's there for a health and safety reason, but in any case, we can set that issue aside. Second of all, I want to make clear that the outdoor mass gathering statute, ORS 433, does not allow the county to impose conditional use permit criteria or other land use criteria merely because it's going to have more than 3,000 people. What ORS 433-763 says is that when there's a gathering, what we call an extended gathering or another gathering, that it has more than 3,000 people and is going to be more than 120 hours, then the provisions of ORS 763 kick in, and the county can bring in land use approval standards, those squishy standards that we're dealing with today. So to answer your question, Madam Chair, about the Marion County Code's mass gathering ordinance, we do have problems facially and as applied to that ordinance. We think it's outdated and it doesn't follow the state statute. The state statute preempts local land use legislation, and it's also outside of ORS 215, the EFU statute, because we're talking about free speech. We're talking about non-land use issues. So the hearings official, I think, spent a great deal of time, and I think she went through a great deal of time unnecessarily describing what farm uses and what uses can be used on the EFU zone. The outdoor mass gathering statute doesn't make a distinction on the zone of where an outdoor mass gathering can be located. It needs to be located out of doors. So that's the regulatory context in which we are in. Now, the opponents and the hearings official and even the county staff have talked about the Oregon Outdoor Mass Gathering Statute definition, which says that unless otherwise defined by county ordinance means an actual or reasonably anticipated assembly of more than 3,000 persons, which continues or can reasonably be expected to continue for more than 24 consecutive hours, but less than 120 hours within any 3-month period. And they focus on this unless otherwise defined by county ordinance. Now, there's a couple of things that I need to speak about on that provision. The statute defines an outdoor mass gathering. The statute also allows the county to define outdoor mass gathering more broadly by bringing in gatherings that are less than 3,000 people. But once the county determines that an event is an outdoor mass gathering, the provisions, the health and safety provisions of ORS 433-750, those are the provisions that are in place. And ORS 433-750 does not allow for a conditional use permit or any other type of land use criteria. So where the hearings official got it right was when she determined that this was an outdoor, that what we are applying for is an outdoor mass gathering. That is correct. We are applying for an outdoor mass gathering, not an extended gathering. If we were an extended gathering, ORS 433-763 would kick in. So the question may be asked, well, why did you apply for a conditional use permit? Well, the county suggested that we do so under the county's ordinance, but as we went through and actually analyzed the ordinance, analyzed the case law, and analyzed the state statute, it became abundantly clear that the county cannot require the applicant to go through the conditional use permit process. That being said, the applicant has spent countless hours and a lot of expense to hire and use a traffic consultant, Joe Bessman, as well as a traffic consultant, Del Huntington, who's here to testify today, to exhaustively go through and look to see what the impacts could be to the farmers. And you'll hear a lot of testimony. There was a lot of testimony in front of the hearings official about the impacts to the potential impacts to farmers. The important thing to understand is that the statute doesn't allow, the ORS 433-750 statute does not allow you to consider those impacts because we're talking about First Amendment issues, okay? Now, the difficulty that I think the county staff and the opponents are running into is they're saying, well, your festival is going to be 120 hours, but you're going to have cleanup, you're going to have setup and you're going to have cleanup, and therefore that kicks you into ORS 433-763, meaning the county can then impose land use criteria, conditional use permit and land use criteria. That is incorrect, and it's incorrect for a couple of reasons. One is because it's a misreading of the statute. The Oregon Outdoor Mass Gathering statute actually contemplates the fact that cleanup and setup is not part of the 120 hours. And the reason is because the 120 hours starts when you have, or you anticipate to have 3,000 or more people. Setup and cleanup never remotely comes close to that level. And so because of that, the hearings official, we believe, got it wrong, wherein she determined that the EFU statute may prohibit an outdoor mass gathering. That's absolutely wrong. She determined that if that wasn't wrong, that a conditional use permit can be applied as part of this. That was wrong. It's also wrong to suggest that because there are going to be more than 3,000 people, the county can impose land use criteria. They can't. And the reason is, and I provided you an analysis of the First Amendment issues, is because the outdoor mass gathering is a First Amendment issue. And First Amendment requires that government cannot impose unreasonable time, place, and manner restrictions. And we believe that it's unreasonable to impose a conditional use permit criteria that requires that there be no significant impact on the farm use, because that is such a discretionary call. And discretion is anathema to First Amendment issues. The way that the Oregon legislature did it is they did it right. They provided the Oregon Health Authority the authority to impose health and safety requirements to make sure that there was enough potable water, to make sure that there were enough toilets, that there was enough police protection. My client has gone through an exhaustive amount of time and effort to make sure that the festival will be run in a way that meets those health and safety standards and will mitigate any potential impacts to the neighbors and the farmers. And they did that, we did that at the hearings official level, but when you read the hearings official's recommendation, you may not even see the work that was done. My client has provided an exhaustive TIA, and in that TIA, they went through the trouble of going through interviewing farmers, interviewing business owners, determining when the harvest season was, what types of equipment would be used, and provided you a table and an exhaustive analysis of why there would be very little impacts to the farmers. We've also established other mitigation measures, call-in lines, and other ways to make sure that the impacts to the farmers can be mitigated. Will there be impacts? Sure, there's always impacts when you're going to have 30,000 people in one location. That's just a given. The question is what is the role of the county? And the role of the county is to make sure that the health and safety standards that have been established by the administrative rules by the Oregon Health Authority, as required by ORS 433, are put into place and are abided by. And we feel that we have met those. Other members of the team are going to be talking about the evidence that was in the record that was essentially cast aside by the hearings official. And I've provided to you letters of recommendation from Lynn County sheriffs as well as Curry County. And there is an Idaho event that is fairly new, wherein these folks have provided letters of recommendation talking about the nature of the festivals that they were involved in. And I do want to point out that the ex parte contact that was disclosed, I appreciate the disclosure of that. Commissioner Nyquist from Lynn County actually voted in favor of the 5-year extension of the outdoor mass gathering in Lynn County. So it's curious that he would cite concerns, and perhaps maybe those concerns can be, I am not going to speak for him, but if he voted in favor of the extension, perhaps he just wanted to highlight some of the issues that are involved. But like I said, there are always going to be impacts to any type of development or use. This is no exception. We have gone to great lengths to show that we have met the conditions of approval for the conditional use permit, should you determine that it's necessary to meet those. In any case, regardless of whether or not the conditional use permit criteria are required, which we don't believe that they are, we still want to be good neighbors and good community partners. So therefore, that's why we've gone through the lengths of providing mitigation efforts to address some of the concerns of the neighbors. We're not going to satisfy everyone, but we have a letter in the record from someone in another festival in Idaho that was opposed to that festival, who later submitted a letter not only to my client, but also the sheriffs, thanking them and praising them for the first-rate event and taking into consideration their concerns. And with that, I'd be happy to answer any questions that you have. I welcome it. I'd like to. It's impossible to go through the legislative and case law history of outdoor mass gatherings and how they intersect with land use, but I'm happy to do that as we speak today.
Well, thank you for your testimony. So I'm looking at ORS 433-763. So assume that we agree with you and say that the conditional use is not constitutional, necessary, legitimate, or whatever. What I heard you say was that ORS 433-763 just requires the county to look at the health and safety aspects, but I'm reading section C, and it says the county planning commission shall, but then in the subsequent section it says that if the planning commission doesn't do this, the county governing body would receive the application, make the findings, and that's how we're doing it here. So any permits required by the applicable land use regulations have been granted, and the proposed gathering is compatible with existing land uses and does not materially alter the stability of the overall land use pattern of the area. So it seems like the subsection for C1 is compatible with existing land uses, would then require the Board of Commissioners to consider whether or not the impacts to farming are significant enough to make it so that the 3,000 plus people that are there genuinely should be there, rather than just looking at whether or not the fire department and the water and garbage and roads and all of the other things we do for mass gathering are in place. So how do you reconcile that with your comment that you made earlier?
Madam Chair, thank you for your question. You've solidified the issue at hand. Let me clarify. If I said that, I misstated.
Okay.
Our position is that what we are proposing is an outdoor mass gathering as defined by ORS 433-735, which requires adherence to ORS 433-750, not 763. If we were proposing a outdoor mass gathering of more than 3,000 people for more than 120 hours, then we would be in the 763 world, okay. And we're not. Now, again, as I mentioned in my testimony, there is confusion on that. In fact, you have the hearings official, you have the opponents, and you have Mr. Reich even testifying that we are in the 763 world. We're not. And the reason is because there's a couple of reasons. One is that ORS 433-765 requires that county regulations regarding outdoor mass gatherings be consistent with the standards of the statute. They can't be inconsistent. To interpret the Marion County Code to say that an outdoor mass gathering is something other than an outdoor mass gathering because there's going to be a couple of weeks of there will be weeks of setup and weeks of takedown after the event is an impermissible reading of the outdoor mass gathering statute. And if you interpret your ordinance to say that that's the case in Marion County, then that would be an invalid ordinance because it would conflict with the preemptive statute.
So could you, so I'm looking at 735, and that's the definition section. What was the second section that you said? 433.7?
So the definition of an outdoor mass gathering is in 735.
Right,
And then once an outdoor mass gathering is determined to be an outdoor mass gathering as defined, then you go to 750. And that is the meat of an outdoor mass gathering statute. Remember when I was talking about the Oregon legislature in the 70s wanting to impose objective health and safety requirements? They wanted some regulation of outdoor mass gathering, but they didn't want to be in the position of violating the Constitution through prior restraint. So they're saying, look, if you're going to have 3,000 people or more, and you're going to be doing it outdoors, overnight, if it's less than 5 days, then you need to do certain things. You need to make sure there's enough water, doctors, fire suppression, sanitary issues. And we believe that the Oregon Health Authority, not the Department of Land Conservation and Development, which didn't exist back in the early 70s, but not any other agency, but the Oregon Health Authority will adopt those regulations. And they adopted those regulations in OAR, and Oregon Administrative Rule 333, and I believe it's Division 59. But they provided those regulations, and those are the meat of an outdoor mass gathering statute. And that is what, in some instances, your Marion County Code exceeds the authority granted by ORS 433 and ORA 333.
Okay, so just let me make sure I'm understanding what you're saying. So
Yes,
in
please.
735, so you're saying that the outdoor mass gathering is less than 120 hours, and I think I heard you say that the reason that our planning folks put it into the longer scope is because they included setup and takedown, and you're saying that that's not part of it? Is that correct?
Madam Chair, that's partially correct. If you look at the Marion County Code outdoor mass gathering ordinance, it defines outdoor mass gathering as a small gathering and a large gathering.
Right.
And it defines a so both are outdoor mass gatherings. And which is okay, I believe, under ORS 433.735, where it says unless otherwise defined by the county. Where I believe that the Marion County Code goes off the rails is where it makes a distinction, or doesn't make a distinction, I guess is a better way of saying it, when it says that the conditional use permit requirements kick in when you have more than 3,000 people, regardless of length of time. Or if you have 750 people or more, then between 750 and 3,000, and it's greater than 120 hours, and the 120 hours includes the time it takes to set up and take down, except for 48 hours before and after. And I think that's where the county, whenever they drafted that ordinance, went astray from the state statute and regulatory scheme,
Okay.
if that makes sense. It takes a while to untangle these, but
All right. Any other questions?
Well, I don't know what my question is, but I'm not buying that we don't have the ability to say that, I don't care what hours it is, but if it's 1 million people coming in for an hour, we ought to have some ability to control it. And you're saying we really have no standing at all,
well,
For the conditional use.
either way.
yeah, I'm sorry. Yeah, so let me rephrase what I said. The county has the ability to regulate up until the legislature says that it can't. And in this particular case, just like the Federal Communications Act that limits what local governments can do for how they can regulate cell towers, Or in the case of Measure 37, Measure 49, the people of the state of Oregon said, well, despite land use regulations, if you've owned property for a certain period of time prior to these land use regulations, we're not going to allow counties to impose those regulations, or if they do, they have to compensate them. This is a type of preemption where the state wanted to walk that fine line of not violating the Constitution, but also providing those health and safety provisions. And I think the reason why they said between 24 hours and 120 hours was because they determined that anything longer than that really wasn't of temporary nature. But something of temporary nature, we're not going to allow the counties to go in and have what Chief Justice Rehnquist once called a heckler's veto. Somebody who says, oh, that's going to impact me. Well, all laws have a conflict, right? There's always going to be someone who's not happy with somebody expressing or using their right to do something. And there's certain boundaries, right? So you can't do anything you want to your property if you're going to be a nuisance or if you violate a zoning law. But there's also other countervailing questions. And in this particular case, it's the First Amendment. And so I think the state did a pretty good job of walking that fine line, and the county doesn't have the authority to exceed that line that's been drawn by the legislature.
Okay, Commissioner?
Yeah, thank you, Madam Chair. So the Oregon Health Authority has the authority to require those things. However, they delegate it in many cases to the county. Would that be accurate?
I believe what they do is they provide standards, and yeah, those standards talk about county involvement, absolutely. Yeah,
So-
the sheriff is going to be involved, Public Works. It's not that the county doesn't have a role to play, they absolutely do. And we've been working diligently with the county, as well as, in this particular case, ODOT.
Yeah, so our health department would be enforcing the rules and that the Oregon Health Authority has set up for a mass gathering of this.
I believe that's correct,
Okay,
yeah.
thank you.
All right. Anything else? So, where is Brandon? Brandon, so the opponent's attorney, you said, is on the phone? Yes. And is he, maybe I should just ask him, is he here for the duration of it, or is he wanting to speak and then not be on the phone for the entire 3 or 4 hours that we're going to be here?
I understand he's here for the duration. They've set it up in a way that everyone gets 3 minutes. They're signed up on an individual sheet. with
Right,
him
I've
at
got
the
his name
top,
right here.
And they're going to use an easel together, so they're kind of in a packet,
All right.
if the board would consider it that way.
And then the code is silent. I sent a note to Jane about whether or not the opponent also gets 15 minutes or the opponent gets 3. So Jane, your advice on that is what?
My recommendation would be if the board wants the opponent to have 15 minutes to seek permission from the proponent.
So in other words, would a proponent's attorney have objection to the opponent's attorney exceeding 3 minutes?
I don't have a chance to confer with my client at this case, but what I wanted to make clear is that we would have the opportunity for rebuttal as the applicant.
Sure.
Okay.
Yeah.
I think that would be appropriate.
Okay, great. Thank you very much. All right, so why don't we, Mr. Bucall, are you on the phone?
Yes, Madam Chair, I'm here.
All right, so we will allow you up to 15 minutes then, with the opportunity for the proponent's attorney to have some chance for rebuttal. And there's no time frame in our code for that either, so we'll have to wing that, right? What do you think the time?
Generally, rebuttal's about 5 minutes.
About 5 minutes. Does that sound? Okay. Since you've been so kind as to give them extra time, we'll give you extra time too. How about 10? Does that sound good? We'll make this up. All right, Mr. Bucall, you're on.
Let's make sure that volume is clear.
Thank you, Your Honor. Well, thank you very much for the opportunity to testify by phone. Can you all hear me okay?
Yes.
A
we
bit
can.
much.
Okay. There's a great deal of material on the record.
I think it's the microphone that's.
I'd like to focus on this jurisdictional issue at perhaps greater length than I had intended to. You have two lawyers here. You're going to hear two entirely different things. I would suggest that perhaps the right thing to do is to listen to the lawyer that we paid, the hearings officer, and her conclusions as to one way to do this. I have an idea that I'd like to propose to make 735, it says that unless otherwise defined by the county. And so the question is, well, how broad is that authority? Now, my opponent has a novel theory here that somehow we have to sort of limit that authority because of some fundamental constitutional right to make money selling country music tickets. There's not any real case authority on that. What we have left of the First Amendment in this country is that if you go to the core political speech, like political protests, that we're allowed to fence people into free speech areas and all this sort of stuff. And so the idea that the Constitution has some protection of country music that would forbid the county from insisting that the thing occur at a reasonable time, place, and manner, like a stadium somewhere, I don't think that that's an argument that any court is going to accept. And so we're left with the bare language of 433-735, which says you can define it. And the hearings officer basically hung her decision almost entirely on that language and said, we've got an ordinance here. It defines small and large gatherings. It defines, when you need a CUP. And this is good enough. This is good enough. And that's an argument that would probably prevail. We wanted to strengthen her decision by asking the board to expressly find that the impact here is for longer than 120 hours. The code expressly says that you add on to the public performance time any time in excess of 48 hours necessary to set up the event or clean up afterwards. And that's what the staff did when they wrote their December 20th memorandum to the hearing officer. They said, even if we give these guys the benefit of the 48 hours on each end, we think the event's probably about 148 hours. Now, I'm not saying that we agree with it just being 148 hours, because you've heard already, even in the ex parte disclosure, that's concerns about how long it takes to clean this thing up. There's a lot of experience in Lynn County. Our first filing back on December 20th put in sort of the entire case history in Lynn County. And the testimony from the poor farmers down there is that this thing began to interfere with operations weeks before the festival started and for at least a week afterwards. And so what we're asking the board to do is just follow the plain language of the code, this section 9.25.030, and define this in a way that makes it clear that it's longer than 120 hours. And with that, we don't have to get into all these questions about how broad is the county's authority to define things, because the statute itself says, hey, if it's longer than 120 hours, they're done. They've got to get the CUP, they've got to show this compatibility, they've got to make all these showings that they can't possibly make. And so we think this is simple. Now, Mr. Reader has filed a letter with you guys yesterday that says, well, we don't think this is legally right. We filed a memo back on, when was that? February 21st, which went through the case authority. And in particular, we cited one of the cases of the Land Use Board of Appeals called Fence versus Jackson County. And I'd just like to read something from that petition. It says, petitioner, who's in the position of the applicant here, argues that it's inconsistent with section 735 sub 1 for the county to include the time necessary to set up, take down, and clean up in the calculation for determining whether a particular mass gathering is of 120 hours duration or more. Petitioner is incorrect. Section 735 sub 1 specifically authorizes a county to define what constitutes an outdoor mass gathering under 735 sub 1. The county is within its ORS 433-735 grant of authority in establishing when the time period used in that calculation begins. That was a LUPA decision. It later went to the Court of Appeals. The Court of Appeals indicated they thought the county had even more authority than LUPA thought they had. So what we get out of that is that we think the Marion County Code is completely legal insofar as its definitional construction between small and large gatherings and when you need a CUP and when you don't. But just to make this perfectly clear, we think that there should also be a finding like the staff made back in December that says, look, we've given these guys 48 hours extra on each end, but in this particular case, it's way longer than 120 hours, and so it's appropriate to go through the CUP process. And so I don't think, if one reads the cases correctly and the law correctly here, that there's anything wrong with the hearings officer's position. I think she referred to both the 7 fairness to 763, but you didn't quite cross the T's and dot all the I's by making it clear that staff had already told her and everyone else had told her this was more than 120 hours on the definition. So that I think is my answer on the question of jurisdiction. The hearings officer is clearly right, and that's why. And before I go on to some other issues, maybe if there's any questions on that, it would be appropriate to do that now.
Well, I'd like to have you stay within 15 minutes on the presentation as we did before so that we can accurately, we don't have to have Christie stopping and starting the timer. So,
Okay.
so if you could continue, then we'll ask questions at the end.
The other things I was going to say, and I do have some written testimony that I can supplement this with, is that it's always been obvious that there's a very bad traffic problem here. The hearings officer correctly found that the traffic control plan here is inadequate, that the traffic forces significant changes in the farm practice, and the applicant just can't even demonstrate that I-5 can be kept free. We had to hire a traffic consultant. We put in his testimony. I believe he's here this morning to say that they still don't have any answer to his concerns. And I think that their answer to all of the problems that were sort of obvious is let's have these people drive around in a giant 7-mile circle going nowhere to fill up space so they don't back up on I-5 so much. But, you know, people have GPSs. They're going to see they're going the wrong way. And this is just a recipe for sort of a crippling disaster. And the idea that we see in the staff report that they can sometime 5 months before a festival in 2019, they can sort of try this again and try and get it right. You know, they're asking me to buy a pig in a poke here. The idea of planning is to sort of identify and resolve the problems before approval, and we don't have any useful and competent analysis of the traffic. And to make matters worse, we have very serious concerns that this 30,000 person limit is not a limit that these people are going to be abiding by, which will make the traffic worse. They started off here asking for a permit for 60,000 attendees, and then when it became obvious that that was hopeless, they cut it to 30,000. But there's a long history of this festival, and a certain amount of people come, and there's a little bit of evidence in the record that says some of the performers on stage were saying there are far more people there, and there's hundreds of other people who have to be there for security and traffic control and health people and vendors and all this. And so we don't think that's been adequately handled at all. The Thousand Friends of Marion County has put in some testimony recently about the disastrous event out in Crook County. But all you have to really do here is look back at the Lynn County history, and the Lynn County history shows that they had continuous problems with the numbers that were going to be there. And we put in a supplemental memo back on December 22nd where we quoted what some of the commissioners said. And the commissioners, found that here's a quote from Commissioner Tucker. We've not had a year with demonstrations that they understand their obligations. I mean, Lynn County ultimately was driven to the point where they sort of went to aerial photography to sort of say, look, you've got too many people there. Now, the answer that they come up with is, well, there's a ticketing platform, and you can look at the ticketing platform build, and that'll solve everything, but it won't. We don't think they give tons of tickets away to all these people who are working and to all kinds of other people, and so there's no control here on the numbers, and the thing has been out of control before, and we think it'll be out of control again. The other issue of some legal significance is fish and wildlife impacts. The hearings officer has found some incompatibility with the refuge. There are also a couple of endangered species in the vicinity. The NEDC has just filed something about a bird. We pointed out that these farmers are under really tight restrictions because of the irrigation district here, which is the irrigation ditch that runs right through the property, is essential salmon habitat. We think it's critical habitat for listed fish, and this concern has just been blown off. And we think that under the Endangered Species Act, which is a really tight act, this is the act that's threatening the water supply of Salem on account of the same fish that are in the ditch. And we think that if the county approves these kind of applications with these potential impacts on the ditch, it'll be potentially liable under the Endangered Species Act, just like the applicant will. Now, Mr. Reeder has admitted this morning that they are obligated to comply with the Oregon Health Authority rules. That's part of what they have to show. The rules require that there have to be roads of all weather construction to get these people in and out of all these places, and that an ungraveled dirt road doesn't work. And so what they have to do is not just build a permanent well and an underground water system, which maybe they can get rid of if they can't get permission for it, but under the health authority rules, they also have to have all these gravel roads all over the place. And they say, well, these aren't really permanent improvements. And we question how you can put culverts and ditches and make, improvements and make 12 or 15 accesses off of county roads and not call that a permanent development. And the statute is clear that you don't get to do permanent developments just because you've got a mass gathering permit. It's right there in section 745 sub 2. No entitlement to make these things. You have to do them in accordance with the land use statute. So what this comes down to is even if you thought they were somehow right and they didn't have to get a CUP, they've got all these other things that have to be allowable under the land use statutes, like the well and the underground distribution system and the roads and the access points and the culverts. And all of these things are just as incompatible with the EFU zone as the festival is itself, because the purpose of them is to be there to facilitate the festival. And so that's why staff said, look, this just doesn't work under mass gathering either because of the permanent improvements. There's some significant issues with requirement to compliance with the health authority's water supply. It's 12 gallons of water a day. That's 360,000 gallons a day. The well can't produce that much. Their plans don't show anywhere near that amount of water being trucked in. The record just doesn't support the idea that they've got an adequate water supply at all, and that's why the hearings officer said, we don't know if this well can even be drilled, the yield's unknown, and the reserve storage just isn't consistent with all these rules. So the conclusion that I come to after all this is we just want you to follow the law, the land use law. It protects the local farmers, my clients. The economic benefits that they're waiving are just, there's nothing in the record to support them. As far as we can tell, what the benefit is that there are some people who will be hired. A lot of people from the sheriff's office and the fire district people will all get hired, and they'll applications, but the people who are going to suffer, they'll get no compensation at all. And what's going on here is just totally inconsistent with the land use laws. And with that, I think I reserve the rest of my time for questions.
No? Any question?
Yeah, just a question. Was Lynn County in violation of the land use laws, in your opinion?
Well, I'm not sure I understand the question. Lynn County had a different ordinance. And so what do you mean by did Lynn County violate? Did they violate the land use laws of Lynn County? Is that what you're asking?
Yeah, you just said that this is in violation of land use laws. So did Lynn County violate land use laws?
Their ordinance interpreted the land use laws differently than yours. If you rewrote the mass gathering ordinance and all the other ordinances, you could say that we can have a gathering of any size no matter how long, and you don't need a CUP. And then this inconsistency would go away. But the way your mass gathering ordinance is written and the way your Title Chapter 17, the EFU zoning district is written and all that, it's inconsistent with your law as it now stands. Does that clarify?
So Lynn County would not have been in violation of Marion County code, correct? What you said?
Okay, well, if they had been subject to the Marion County code while they were in Lynn County, they would have been illegal there. But because they were in Lynn County with a different set of regulations, they didn't have this problem.
Okay, so just to clarify then, it's our code that you're saying we would be in violation of.
Yeah. If you apply your definitions of gatherings and your start time, takedown time, and small gatherings, it's by applying your own definitions in your own code that triggers the conflict with the land use laws.
And that's under our
Second category, which is the permanent structure problem, and the permanent structure problem is sort of an entirely separate and independent argument.
Okay, thank you.
So, just to reiterate, what I thought I got from your testimony is that your view of county authority under the state statutes is much broader than the proponent's view of the county's authority under state statutes to set our own parameters for a large mass gathering. Is that a correct statement?
Exactly. We think the statute means what it says, and that unless otherwise defined by the county, gives the county a lot of authority.
And then in terms of the definition discussion that we had with the proponents, so I heard you use 148 hours. Anyway, it was bumped up over 120. Would you tell me then just how you give me the math equation that you used to get over 120?
Okay. The equation that I used to get over 120 is that we take the event duration. If it takes 3 weeks to set it up and a week afterwards, that's like a month. And if we subtract off 48 hours from that, we're just well over 120. I don't know what the staff did when it estimated the time, but if you go back to the memorandum that they have that was dated December 20th that they gave to the hearings officer, they somehow came up with an estimate of 148 hours.
Okay.
I think that was before the testimony was in the record, showing just how long it took to get this thing set up. And people stood up and talked about interruptions to their business and this constant problem with trespassers wandering around in the area trying to find the festival site, and it just went on and on. So I don't have a precise number for you.
Okay. So what I heard you say is that you're relying on a staff memo dated December 20th that set the estimate of time at 148 hours, which then exceeded the 120 hours and put them into the definition, that different set of statutes that allows us to look at the compatibility with land use.
Yeah, what Mr. Reeder said, and he was correct, is that your ordinance would require a CUP anytime you were over 3,000, even if it was less than 120. And so that's one level of county power. And we think that the county has that power. However, where it's more than 3,000 and more than 120, then there's no question, because then you fall straight into 763. And as you pointed out in your question to Mr. Reeder, when you fall straight into 763, there they are. They've got to be compatible, and there's no question.
Okay. All right, that makes sense. Thank you. Any other questions? All right. So do we do rebuttal now then? Would that be the appropriate thing to do? All right, so Mr. Reeder.
Madam Chair, Commissioners, again, Mike Reeder for the record. I'd like to respond to the comments made by Mr. Bouchal. First of all, there's a couple of things. There's a lot here, but the first one that I want to call your attention to, I think is the most critical one, is where Mr. Bouchal says that the county has the authority to have a different set of regulations. So when asked about whether or not we'd be violating Lynn County's ordinance or our own ordinance, Mr. Bouchal, if I could summarize, basically said, look, the county has the authority to write the rules, because ORS 433-735 has this language that says, unless otherwise defined by the county. Again, I would defer to the February 21st, 2018 letter that I provided to the hearings official that she summarily dismissed, didn't even discuss it. It's in your packet, wherein I go through the analysis in great detail. But if I were to summarize, what I would say is, in speaking about the fence case, the Jackson County case that Mr. Bouchal described, in Jackson County had a very different ordinance than Marion County. Jackson County had made a distinction between an outdoor mass gathering, as defined by the county, and an extended mass gathering, as defined by the county. Here in Marion County, you do not make that distinction. You define a large gathering and a small gathering as an outdoor mass gathering. You don't make a distinction between outdoor mass gathering, that kicks you into 433-750, and an extended mass gathering, 763. So to the extent that Mr. Bouchal wants to rely on the LUBA decision in the fence case, wherein the LUBA said that, hey, there's some discretion on the county. That may be that may be all well and true, except for the fact that even as defined, the outdoor mass gatherings statute of ORS 433. Let me grab the statute here. Says that those rules that are adopted by the county cannot be inconsistent with the other provisions of the statute. And let me explain to you why an interpretation that the cleanup and the setup kick this application into an extended mass gathering is incorrect. And it's because the statute itself determines that setup and cleanup is not part of the 120-day period. And it makes sense because any mass gathering is going to necessarily have more than 48 hours to clean up and more than 48 hours to set up. It's just the nature of an outdoor mass gathering. It takes time to do these things. So if you were to interpret the statute the way that Mr. Bouchal wants to interpret it, would essentially suck away the protections of the First Amendment protections of ORS 433. And I provided you a memo to that effect. The hearings official had it. It's dated February 21st, 2018. Now, there are some other misstatements by Mr. Bouchal that I want to discuss. And one of those is where he talked about the ex parte disclosure about Lynn County's concerns. First of all, it makes no sense to cherry pick meeting minutes from 2013, 2014, whenever those were cherry picked, and say that the Willamette Country Music Festival wore out its welcome or exceeded the number of people that were allowed at the festival. That's simply not true. And we know that that's not true because we have Lynn County adopting not only a 1-year approval, but a 5-year approval for the outdoor mass gathering in Lynn County. That was very recent. So whatever problems, traffic-wise, trespassing-wise, any of those issues that were of concern before 2014 were not a concern after that time. We have, and I've provided to you again in the record today, we have a letter from the Lynn County Sheriff saying that they received no calls for trespass. Very few arrests for DUII, and a small number of minors in possession. So the Lynn County Sheriff's Office doesn't have the concern that Mr. Bouchal seems to be concerned about, and we believe it's based on a desperate attempt to stop this at all costs. So I would call your attention to the folks with the badge that actually enforce the law on this issue. Secondly, we believe that his concern about exceeding the 30,000 limit, that is wildly off base. And if you look at the numbers of folks who attended the Lynn County Willamette Country Music Festival concerts, it was well below what they were allowed to have at that time. And I'm not exactly sure what Mr. Bouchal wants us to do in terms of showing that it won't exceed 30,000, but merely speculating, on a wild assumption, is not a way to make a decision. It's simply not the case. And the fact that Lynn County wants them to stay and has approved for them to stay is evidence that Mr. Bouchal is wildly off base. In terms of the impacts to the refuge, we have Brian Marion, who is a wetlands and wildlife specialist, who has provided 3 letters into the record testifying to the fact that the festival will not have a significant impact on the wildlife refuge. And I find it interesting that the folks who are suggesting that the number of people that will be attending the festival will somehow have an impact on the wildlife refuge, I'm a bit confused by that, because the wildlife refuge is going to have a visitor center where they're encouraging people to come to the wildlife refuge. So concerns about, so the hearings official kind of addressed this. She said, I'm not suggesting that people, I'm not making my decision to recommend based on the fact that there may be trespassers. That issue is not before you, and we know that because the Lynn County Sheriff's Office had no calls for trespass. If there was serious concern about trespass or fire or all those other things, Lynn County would have addressed those. And that's the extent of my rebuttal of Mr. Bouchel's remarks.
Thank you. Any questions? No? All right, thank you very much. All right, so now we're down to public testimony. We're going to take, as I mentioned, the supporters first. I think I have the pages in the order that you signed up, but there are no page numbers on the last three. So I'm going to start with Trina Yoakum, and then there are two chairs there, so I'm going to call two people at a time so people can be on deck and we can move through this as quickly as possible. So after Trina is Dell Huntington. So is Trina here? Oh, you didn't sign up to speak? Okay, how about Dell Huntington? Did you sign up to speak? All right, and then the next person would be Carol Hampton? Not here? All right, thank you. How about Sarah Gross? All right. How about Michelle Lovato? Doesn't wish to speak. Thank you. Tammy Robbins? No. Michelle Nunes? All right, you be second. All right, and then after that would be Robert Rossiter. Did I say that correctly? Are you here and do you wish to speak? Okay, so you'll be coming up, and then Brian Malini? I'm sorry, what is that? Myring. Okay. I taught junior high, but even that I can't read. All right, so you two will be up next. So yes, Mr. Huntington.
Thank you, Madam Chair, members of the commission. I turned on my stopwatch cell phone so I don't exceed my 3 minutes.
All right, thank you.
I'm Dell Huntington with Huntington Traffic Solutions. I, along with Joe Bestman of Translate Consulting, have done the traffic analysis in coordination with the county, ODOT, and ODOT Rail as part of the required analysis. Joe is unable to attend today as he's a member of the National Guard and he's in exercises this week, so unable to participate. We have had numerous meetings. I went through my calendar. We probably have had over a dozen face-to-face and teleconferences with both ODOT and county. Often those were coordinated meetings with both the county and ODOT staff. Then we had numerous calls with ODOT Rail and with Portland Western Railroad. So over the beginning since December, we've met on many times, probably at least 12, and numerous phone calls and conference calls. So I think the one thing that was we found, the February 20 TIA, both ODOT and the county found problems with the way we had proposed to mitigate traffic. So based on additional meetings, we worked with them to see what they needed to see in the TIA to mitigate the traffic. And as a result, we developed another revised TIA that was April 6, 2018. One thing that was very serious from my perspective is the hearings officer omitted that ODOT had responded to the revised TIA of April 6th. So there's quite a bit of commentary in the recommendation that ODOT never approved the revised TIA. I'd like to draw your attention to a letter we submitted to the commissioners on June 16. And on page 2, there was actually a memo from Keith Blair, the ODOT region manager, who said that the primary and contingency routes combined with the proposed temporary traffic control recommended within the study may be expected to acceptably mitigate traffic effects of the proposed mass gathering. That's also consistent with the findings of Cindy Schmidt's staff that we've worked closely with. And in their April 20 memo, they say, following review of the materials submitted, we believe that, I'm paraphrasing now, the Public Works Engineering Division is not opposed to the proposal, providing following mitigation measures are met. those mitigation measures, a lot of them are in the temporary traffic control plan. We've met on numerous occasions with them, and we continue to. We're very close. I believe we're very close. And ODOT has requested that as we monitor the event in 2018 in Brownsville, we've invited county and ODOT staff to participate and come down. ODOT has requested that we wait until they see data from Brownsville before they approve and accept the final temporary traffic control plan. My 3 minutes is up.
All right, thank you.
Go ahead.
Hi, my name is Michelle Nunes, and I am the president of the Jefferson Area Chamber of Commerce. I represent today the voices of over 100 different businesses in and around the greater Jefferson area. We would like to ask the Marion County Planning Commission to please approve and support this festival coming into our community. Jefferson is a small area, and we respect the farmers. We're historically a farming community. But we believe that Bi-Mart has tried to address issues. Bi-Mart's tried. You have a couple people that it just doesn't seem they want that to happen, and I'm sorry for that. This festival offers our small community an increase in local economy for our nonprofits, our schools, citywide improvement. We expect to work out some of the problems. We're more than willing to do that. We know that it's not going to be smooth sailing the first couple of years. There's always adjustments in anything. We're willing to do that. There is some impact, obviously, but we believe that that's negotiable. We think that overall, from what we've heard from Ankeny Wildlife, is that it's not going to affect them, and they're not quite sure why they're being kind of tossed there, because the animals aren't really doing anything that time of year. We're not political, we're personal. We all live in and around Jefferson. We want to respect the farmers and their needs too. However, overall opinion seems to be in support of the festival. So we're asking that you consider the impact that it's going to have on, again, over 100 businesses in and around the Jefferson area. These are direct sales, these are home businesses, contractors, private handyman, that kind of thing, and not to mention your brick and mortar businesses. With that, I just want to say thank you, and we ask you for your support for the festival. That's it.
Thank you. So Robert Rossiter? And Brian, you're up next. Thank you. And then we have Judy Solanini. So you want to speak? Okay, great. So you'll be up after this group. Go ahead.
Okay, my name is Bob Rossiter, and I want to thank you for allowing me to present my views dealing with the transportation aspects that are part of this hearing. I have 22 years of experience in the transportation industry. This includes 10 years of driving for MTR Western, a luxury motor coach line based out of Seattle, Washington. Much of my work for MTR is similar to the kind of event we're discussing here. While my home terminal was in Eugene, I also had extended stays in Spokane, Everett, Seattle, Portland, and San Francisco, working out of the terminals in those cities for that company. I want to recognize the concerns about heavy traffic in the area. I understand. I've spent hours during driving in rush hour traffic behind the wheel of a 45-foot motor coach, especially in Seattle and San Francisco, having 50 people sitting behind me asking if there isn't a quicker way to reach our destination. This kind of experience taints our view of what will actually happen in the situation we're dealing with. This is why I emailed a traffic comparison of similar venues to Mr. Wright, which included Leavenworth, Washington, the Boeing plant in Everett, and also Autzen Stadium in Eugene. I'd like to add a few short comments about these locations. Somehow in Leavenworth, the city boasts to have 1 million visitors in the month of December, which means they have about 200,000 each weekend. The 2 lanes of roadway they have to exit the town aren't overburdened. The Boeing plant in Everett has 46,000 plus employees on site, with approximately 20 to 25,000 leaving at the end of a day shift, with another 5 to 10,000 entering the plant. The 3 lanes of traffic available for exiting employees are enough to reduce traffic back to normal in about 45 minutes. There's no noticeable difference in the evening shift employees going home. The Leo Harris Parkway at Autzen Stadium is a 2-lane, 2-way road with a left turn lane. Organizers have perfected their exit strategy to allow 30 to 40,000 fans to leave the venue and have traffic back to normal in about an hour. Yes, there'll be times of heavy traffic. Occasionally, the festival will have to shut down portions of roadway to accommodate ag vehicles. That's just the nature of the beast when you have a major event in an agricultural area. The festival may also need to avail themselves of off-site parking, provide shuttle bus services to alleviate some of the difficulty. But my experience has taught me that the traffic situation at this venue can be dealt with appropriately. I'd also like to make two references to the hearings officer recommendations. While I don't agree that applications should be denied, I do believe, as recommended, that conditions are appropriate. As the officer stated, if the Board of Commissioners disagrees with the hearings officer's recommendation and approves the conditional use permit, the hearings officer recommends that all conditions proposed by Marion County Public Works, the Oregon Department of Transportation, as well as any conditions proposed by the U.S. Fish and Wildlife Service for the protection of Ankeny National Wildlife Refuge, be imposed by the Board. All such conditions are necessary to protect the public health, safety, and welfare, and to protect persons or property. It is my hope that the application will be approved with conditions, and as the hearings officer stated themselves. Okay, thank you.
Thank you. So Brian?
Madam Chair, I'd like to ask your leave to allow John Bishop of the Oregon Sheriff's Association to speak before Brian Myring. He's got to leave before 11. Would
Sure.
that be?
Sure.
Okay.
Thank you, Madam Chair.
Thank you.
Commissioners, thank you for reminding me why I loved public hearings and commissioners' meetings. I'm a retired sheriff, 30 years of law enforcement in Southern Oregon.
Could you say your name for the record?
It's
please?
John Bishop.
Thank you.
I now live in Sublimity and love it up here. I'm coming to you from a slightly different perspective. I have, and my wife have volunteered with the Weimar Willamette Country Music Festival for the last 8 years. We helped start the Cape Blanco one. We helped start the Mountain View, or Mountain Home one. We helped start the Country Crossings, and I've helped at Brownsville. My particular job is the artist security and backstage, and my wife's is with meet and greet and some other things, and being the liaison with the law enforcement agencies in each one of those. It's interesting that every time that we start a new one, a lot of the same arguments are brought by opponents. They will hear certain rumors and then they turn those in to make them fact, or they just assume some things will happen and then try to make them fact. I can only give you what my observations are in all of these areas and working with these festivals. I have seen worse things at a Ducks and Beavers football game than I have in the 4 days or 5 days of being there in regards to some of the arrests, alcohol, and such.
Only when the Ducks lose.
Only, yes, I would agree. But what I would tell you is are there impacts? Yes. Is there alcohol impact? Yes. But almost all of those are inside the venue. All of the sheriff's offices, I believe, have testified before you in written form at least, that really with the amount of people that you have, the problems that you have there are few. The Deweys have surprised all of us at every venue that, or lack of, to the fact where the state police does not even bring their mobile van anymore because the arrests are just not there. Most of the people who do partake in the alcohol stay on venue, and we've not had that. Are there crimes committed? Yes, there is. Always going to be when you have that amount of people. But I can tell you that I would not be part of this company. I don't believe Weimar would be part of this company in volunteering our time, doing something that we enjoy if this company was not up front and trying to mitigate everything that they've had thrown at them. Ann has done a wonderful job. She is great to work with law enforcement.
Thank you very much. You can just finish your sentence.
Well, I just think that if you ask the law enforcement officials who have been involved in this, that you would say that it is negligible, and that Marion County, with your fine sheriff's office is probably more equipped to handle this than any sheriff's office that has had these in the past.
Thank you.
Thank you very much.
Brian, thank you for your willingness to allow a person to cut in line.
Brian Marion, Wetlands and Wildlife LLC. I'm a private consultant specializing in land use, conflicts with natural resources, and I'm testifying on behalf of the applicant. I've submitted 3 letters into the record discussing why the proposed festival is not expected to adversely impact fish, wildlife habitat, or critical habitat. I've also submitted information related to Ankeny Wildlife Refuge and have clarified the intent of the U.S. Fish and Wildlife Service letter, which is dated December 5th, 2017. This letter was discussed with the refuge manager to clarify. In terms of the opposition, many comments have come into the record regarding the proposed venue and claim that there will be known or unknown impacts, adverse impacts to fish, wildlife habitat, and/or critical habitat. These comments relate this habitat and wildlife impact as occurring primarily on refuge lands and species which are outside the venue. The refuge also commented and had some concerns in their letter dated December 5th, 2017. A discussion with the refuge manager clarified that there were no biological concerns related to the venue, that they, not the applicant, would prefer to work out details related to their concerns after the county would approve. And the applicants are amenable to this. Since the applicant originally approached the refuge regarding the proposed venue, it is reasonable to expect that this coordination will continue. The proposed festival is located on private land, and the only impacts which are expected based on the application occur on this private agricultural land. Although the refuge abuts the proposed venue, there are no defined impacts expected to the refuge, which cannot be mitigated through future coordination with U.S. Fish and Wildlife Service. There are no comments provided on the record which substantiate impacts to fish, wildlife habitat, or critical habitat, which would reasonably lead the county to deny the proposed use based on those factors. What I continue to recommend is conditioning the approval of the proposed use on coordination with the U.S. Fish and Wildlife Service. Thank you.
Thank you. I think Commissioner Cameron had a question. Is that right?
Yes, thank you, Brian. We heard earlier testimony, I think, from the opponent's attorney about a ditch and its impact on salmon habitat or protected species. Can you comment on that?
There is a ditch which bisects the venue, which will not be impacted by the venue due to a spanning bridge which crosses it. So there's not going to be any permanent, there's not going to be any structural things built within the ditch. There will be a spanning bridge over the ditch.
There's a current bridge?
I'm not sure if there's a current bridge, but there will not be a culvert, there will not be fill within the ditch, which would constitute an impact.
Thank you.
Yeah.
Thank you. And it's Judy, and I probably didn't pronounce your name correctly.
Cellarini.
Cellarini, okay. That's close. All right, go ahead.
I have a letter to read in response. This letter is in response to misleading information.
Can you get really close to the microphone? Thank you.
Okay, now?
Yeah, you have to kind of eat it.
Okay. Tastes good.
All right,
Is that good enough?
Perfect, yeah, I can hear you now.
This letter is in response to misleading information submitted by those opposing the festival. Supposed issues regarding the Ankeny Wildlife Refuge, road closures that impact harvest rumor surrounding the compensation regarding the festival, and most importantly, the impact of the local community and county. First, we would like to address the response issue regarding harvest conflict in the surrounding areas of the proposed festival site. The Gross Family Farm farms more acres in the area than each of the opponent farms, opposition farm. Seed is the largest crop grown in the area. We would like to emphasize if there were conflict with the harvest, it would affect us all as well. But contrary to that, others have stated harvest is well over by the middle of August each year. This includes the removal of the straw bales, and the land is then sitting idle until fall tillage. We would like to also address the documents submitted by farmers to the hearing officer. Some of the fields outlined are not close proximity to the proposed festival site, especially Morning Star Grange, Harnish, Richardson Gap, Gravel Pit, Viewcrest, Higby Farms, Robinson Road, Pilchers. Most of these fields are not even in Marion County. We are confused to why these farmers chose to submit these documents. This land does not pertain to the area that we are asking for the festival. The Myers family is opposing the festival and has complained about the conflict with the harvest, yet they had time to attend the same festival a year ago prior in Brownsville. Also, Jensen's family, Willamette Valley Storage, have stated that they are concerned about making numbers of trips up and down and local farm roads each day of the festival, yet they do not harvest or have any farm activities on Sundays. One of the 4 days of the proposed festival is the dairy farm claimed the milk produced by the 500 cows could perish as a result of the traffic caused by the festival. We have talked to other local farmers, dairy farmers who have 1,000 cows whose property is adjoined to the Jager's Dairy, and it's confirmed that the milk is picked up every other day in the early morning hours before the festival traffic would even begin. We would like to address some of the concerns regarding the Ankeny Wildlife Refuge. We farm 250 acres of the Ankeny Refuge. When we are working the land with our heavy equipment, making noise, the elk and the deer are roaming around. Coyotes are catching mice. Seemingly, our presence haven't had but little or no effect on the wildlife. If there was a negative impact on the wildlife, nobody would be permitted to farm the refuge. Okay.
Did you want to finish your sentence?
That's okay. I just want to say, I've lived in Jefferson all my life, and I've never seen a town complain like we're doing. It's sad. I have a 3-year-old
Okay,
great-grandson.
you're well beyond your 3 minutes
Oh,
now, so
okay.
is that letter one that you've already submitted, or would you like to submit that as written testimony?
Submitted. I think it needs to be submitted.
Okay, so would you provide that to legal counsel then, and we'll put it in the record? Thank you very much. I skipped over to, is it I.B. Jones or J.B. Jones?
Okay, thank you.
No one responding to that name? Okay. So that is everyone who is for on that page. I'm sorry, what? And we've got Peter O'Rourke. Did you want to testify? Pete, I'm sorry. And Tim Flowerday? Okay. And then Scott McDowell, you'll be up next. Helen Funk? Yes, no? Is Helen here? Did you want to testify? Okay, great. So you two will be on deck after Pete and Tim. So Pete, would you say your name for the record and give us your testimony?
Thank you. My name is Peter O'Rourke. I'm a retired lieutenant with the Oregon Liquor Control Commission. Previous to retirement, I was 10 years as a police officer, 30 years with the commission, 28 years as the manager out of Eugene, which encompassed 5 counties, which included Lane County, and Benton County, and Douglas County, which meant I had responsibility for both universities, Oregon State University and the University of Oregon. Anything over 1,000 people, I approved those liquor licenses. I signed off on them and made sure that they complied with the alcohol laws. What I'm trying to get for here is that for the last, since the festival's been there, I've approved their liquor license. And I have never given them a warning or a violation since the period of time that they were in operation. When I retired 2.5 years ago, I became a volunteer for the festival. I was responsible for alcohol service and security. The commission was very vigilant setting up policies and procedures to make sure that alcohol was served responsibly at the venue, and that security was all certified, and that we had security policies and evacuation policies all in place. Since the time I have been there, alcohol violations have decreased, crime has decreased, and we've watched that progressively happen over the years. Currently, the festival has a zero tolerance to alcohol violations. Anyone who is caught with alcohol or commits a crime or a violation is immediately ejected from the festival and is never let back in. Security also, we've increased that and made sure that we had more security than was actually needed for the festival to make sure that things don't happen in there, that security is certified and capable of doing their jobs. Alcohol service, we make sure that we also include training for all the servers. Each server that works for the festival has to have a service permit, and we provide daily trainings for those servers and go over the laws and rules. We've even put in a security person at each service area to make sure that if the server thinks that a person has had too much alcohol to drink, that they're immediately cut off, and that security person is there to escort them off the premises if that's what's required, if they're creating any kind of disturbance. We make every kind of effort to make sure that things are lawful and abiding, and that everything is going to keep moving in that direction in the future. In summary,
You complete your sentence.
In summary, I want to make sure that everyone's aware that we have, our alcohol violations are decreasing, and criminal laws that are broken on the festival are also decreasing.
Thank you. Jim?
I'm asking Peter to stay because I'm hard of hearing, so if there's questions, he can
Okay,
interpret
go
for me. I have been an event manager or event consultant
you need to
for
say your name.
34 years. My name is Tim Flowerday.
Okay, thank you.
And a chamber director for 8 years. I actually received a key to the city of Springfield for community involvement with my events there. Have been a director for the Oregon Track Club and managed most of their running events at one time. And at one time managed most of the running events and biking events in Central Oregon, in the Valley. And in addition have managed festivals for almost 25 years, including the world's largest toga party and many other events that have come and gone over the years. But for this festival, for 10 years, I have been the operations manager. And as the operations manager, I'm the person who oversees the building, the tearing down, and the smooth operation of the event during the event's production time. I think that, and I don't really think that I'm biased when I say this, we have one of the best operations teams in the festival business. We have a very experienced team of people like Peter, and we have another person, Peter, that is going to speak later about sound reinforcement. They are a mature team that has been around a long time. We are not a fly-by-night organization. We're not fly-by-night people. We believe in the long term, and our operations reflect that. Safety is our overriding concern. We develop systems and evaluate them each year in terms of how we manage sanitation, how we manage production, how we manage the security teams that are on the festival grounds, and our interactions with law enforcement and the communities. In Lynn County, when we first approached Lynn County with a permitting process, they faced a lot of the same issues that you did, and I worked with Rick Partapello there in terms of developing the mass gathering ordinance that they have now, and we did that together as a team.
Just complete your thought.
What's that?
You can complete your sentence.
To create an ordinance that not only benefited the county, but would be well understood and clearly defined for festivals and events going forward. And I think that we have the ability to offer that same kind of partnership here.
Great, thank you very much. Scott, McDowell, Helen, Funk. And that concludes that page of proponents. And then I've got Dan Gilmore. Are you still here and want to testify? Yes. Okay, and you're a proponent?
Yes.
Great, okay. There was like a line through your support, so I just want to make sure. And then Reed Anderson? Yes. And you want to testify? Yes. Great, okay. Scott?
Thank you, Madam Chair. Thank you, Commissioners. I'm not sure how I follow a toga comment. I'm not sure.
Better than me.
Yeah, I know. I would just like to say that my name is Scott McDowell. I'm the City Administrator for the City of Brownsville, here on the request of City Council. I started my career in public service in 1992. I attended Bowling Green State University, earning a master's degree. I've been with the City of Brownsville since January 1st of 2007. The thing that I want to say is, I know I've heard a lot of things said over the years that the city and I have received a lot of money. Franklin Delano Roosevelt is on the dime, and we have not received one dime of financial benefit from anything that Bi-Mart or Willamette Country Concerts has done. We have been in the line of fire with the commissioners. It's like the Seattle Mariners playing a Little League team. So council had to make sure, the reason why I say this is because honesty, integrity, and trust are three huge components of public service, clearly. In my line of work as a city administrator, an average city administrator makes it to 3 to 4 years. I've been there, I'm in my 12th year. So we take that very seriously. We would not question anything that the commissioners did out of our purview based on anything other than the facts and the track record. There is a difference between, of course, the laws in Marion County and Lynn County, and I do recognize that. But I'd also say that Marion County is a different situation in that Lynn County, when they went through this, did not have any history. They did not have any track record. What you have in front of you are professionals who have a track record of excellence that surpasses anything that I've ever seen. I was in Nashville, Tennessee for 5 years and very close to the country music industry from that standpoint. In terms of traffic impact, life, health, and safety, the event organizers have always met and exceeded the requirements put forth by the county and the state. Which is the only reason why the city council continues to send me forward in support. If they did not have that quality reputation, that would not be happening. I also want to say that they do provide a lot of opportunity to the broader community. They have helped the Central Lynn Recreation Association. They have helped the Central Lynn School District. They have helped the Brownsville Fire Department. They have helped Sharing Hands. Their commitment to the community to provide opportunities for the Brownsville Chamber of Commerce have been tremendous. All of those are nonprofit organizations. Gary Strawby used to own Dairy Marts. I called him trying to get a matrix one time of how it was having a positive or negative financial impact on businesses. Both the gas station owners and Mr. Strawby indicated it was the biggest day in the history of Dairy Mart. I said, well, just in Brownsville? He said, no, of all Dairy Mart. I just say that because the economic opportunity is great. Of course, the commissioners are interested in tourism and economic development also, but I just want to finish with the fact that you have folks here who have a proven track record and who will continue to meet and exceed expectations. Thank you, Madam.
Thank you. So Helen?
Good morning. My name is Helen Funk. I'm the president of the Central Point Chamber of Commerce, as well as being the director of the Jackson County Expo, which is the home of Country Crossings. I want to thank you, all of you, for just even giving me a moment to say a couple of things. And I guess I want to start off by saying this is not something to be feared, but something to be celebrated. You have an opportunity in front of you to embrace something that that has never been done here before. And as a chamber executive, I will say it will bring not only business to your businesses that will extend long beyond those 4 days of your life, it will also bring education to people and visibility to your area. Those of us who have never actually even understood what was available in Jefferson. I didn't know there was a refuge here until I started studying where the festival is going. So I think it's what you look at. The other thing that I don't think that has been brought up today is emergency preparedness. And looking at what happened with us, I listed out 15 different agencies that came together to put together the Incident Command Center that worked with this festival. Multiple times a year, this group of people got together and were working on all the different ins and outs of what could happen with the festival. Not only did they meet their mass gathering conditions, and they had several, and even after our first year was rocky, they came back and they did very, very well. But if you take into account fire, sheriff, police, probation, parole, OSP, ODF, Mercy Flights, Jackson County Roads, Oregon Department of Transportation, Jackson County Parks, Jackson County Expo, Asante Medical Center, Providence Medical Center, Wilderness EMTs, etc. All of those people coming together to talk about what ifs and how to carry things off. If anything ever happens in Marion County, this group of people have now pulled this off, and they will now be closer than they have ever been before. That is an unintended outcome of this festival. The other thing is they don't tell you the things that they do for your area that aren't measured. The number of tickets and wristbands that are asked of them, the meet and greets, the different camping packages that every nonprofit under the sun asks for auctions and donations. The number of people that come to this festival and ask for sponsorships. These dollars all go back to your community and to your nonprofits. Right here, and they don't ever account for those. You'll never see that number, and they will never shout from the mountaintops the great things that they do. So I wanted to take the time today to make sure that you were thinking about those types of things. Think about the outlook and the visibility that you've got right here before you. Think of the celebration that can take place not only with fun and friends, but as well as on the serious side of emergency preparedness, visibility, education for all of those people who are about to visit your county. Thank you.
Thank you. So we have Dan Gilmore, is that correct?
Yes.
And Reed Anderson, you're up next, if you'd come up. And then Jimmy Gross will follow. Go ahead.
Thanks for the opportunity to speak today.
You need to say your name for the record.
Dan Gilmore.
Thank you.
I've lived in the neighborhood for 63 years and my family over 100. And on both sides of the issue, you know, I consider myself a neighbor and a friend. But when I see the numbers that my neighbors and farmers are putting as losses, I think if this is approved, it's to set a precedent in Marion County for a gathering and size. And I don't know how these huge numbers can be, you know, projected when this has never happened before. And certainly it's going to have some impact on the neighborhood. But overall, I think it's a very positive thing. Secondly, I'd like to speak to the Gross family. I've known him for a close interaction with the family for 55, 58 years. And you won't meet harder working people. And first and foremost, they're farmers. They're not concert promoters. And as you read some of the things in the local Facebook and things around Jefferson, it's become kind of a personal attack on the family that, oh my gosh, they might get compensated. But, you know, these guys, and don't quote me, I think they farm about 4,000 acres with 4 or 5 employees most of the time except during harvest. And I think at the end of the day, if we make a buck, that's why we all get out of bed. So I hope you take everything into consideration and approve this. Thank you.
Thank you. Reed Anderson.
Hi, I'm Reed Anderson. I'm one of the farmers in Brownsville that the Willamette Country Music Fest kind of started on. So they kind of cut their teeth on me, which was, I'm sure, a pretty huge endeavor to try to overcome. Kind of what I want to speak about, I want to support them as well as the the farmers that are in support of this. Because it takes a lot to raise your hand and say, yeah, I want to have 30,000 people on my property. And so there's a lot of considerations that have to be made. The reason we entertained the idea back in 2008, there was not a whole lot going on in the economic picture, and we kind of looked at this as a way to bring attention into our area and some dollars, and it definitely has done that for us. We grew substantially over the years, and I say we because we were always talked to about what the next year brings. There was never anything hidden, or we never felt like there was any kind of an agenda. I mean, the farmers in our area that I neighbor with, we only have one guy that's kind of in opposition, and he became opposition after he figured out he couldn't make any money off of the festival. But the rest of us, we all work together pretty darn well. And what I have to say is these are very professional people, and they've gotten more professional over the last 10 years. They just do a wonderful job, and I'd really hate to see an opportunity for you guys to be missed over a few technical things like ordinances that could possibly be changed very quickly. As far as an impact on us, there is basically no impact. Our harvest is done. Our animals are off our home property where this is held. The straw is gone. It just comes at a really perfect time of year for us. The value for us is bringing in all the people to agriculture, to get these urbanites to understand what happens in agriculture and how we can all share about lifestyles. Also, I'm in the meat business, so it's a really good opportunity for us to bring in all of our partners in the retail and food sector. Part of it, they could come to the Anderson Ranch and see what happens and see that we're not only just farmers and ranchers, but we're into our schools and our communities. And just, we really try to get the big picture. Thank you very much.
Great, thank you.
Just a quick question.
Okay, quick.
Jimmy Gross.
Just wait just a minute. Commissioner Cameron has a question.
Mr. Anderson, I just wanted to know if you shot any ducks this year.
Did I shoot any ducks? Several.
Okay. Thank you. All right. Jimmy Gross, thank you very much.
Hi, I'm Jimmy Gross. We own the land that the festival wants to move to. We farm about 4,000 acres, and about 1,800 is in the vicinity of the Jefferson, Talbot, Ankeny Refuge area. We see no impacts to our farming capabilities, and we will we look forward to having the festival on our property. Thanks.
Thank you. Peter Yoakum and Ann Hankins, you're the last two that have signed up in support. Then we'll start on page 1 and go all the opponents.
My name is Peter Yoakum, and I come to you to speak about what I know about the sound systems that are going to be used at this festival and how they will meet and exceed the requirements of the noise abatement aspect of this. The company that the festival has hired is a very experienced sound company, and they bring the most advanced sound equipment that's available worldwide to this festival. And the way it's deployed, it provides a very good experience, coverage for the audience, but little impact to beyond the boundaries of the festival. It's the way sound systems have been propagated through the last few years. There's been a huge increase in the technology, and they're able to keep the concert venue at a very loud level, but not exceeding the boundary of the property. And it's an exciting time in my life because I work in the sound industry and seeing the development of this stuff. And Because of these kind of equipment, we're able to be louder in the boundaries and less volume outside the boundaries. And that's something I've experienced in my life, and knowing the equipment that these guys have. They are also the sound company of record for the sound system that was installed at the Hollywood Bowl in California, where there's even greater restrictions for sound pollution beyond the boundaries, and using the exact same components at both these, the Willamette Music Festival and what happens at the Hollywood Bowl. They meet and exceed the, not exceed in the sense of they've broken the law, but staying within the boundaries of what the noise ordinances are.
Great. Thank you very much. Ann?
Madam Chair and Commissioners, I am the promoter of the Willamette Country Music Festival, and I know I have 3 minutes, so I will try to get through this. Ann Hankins.
Thank you.
I want to say first that, there's been a lot of slant on country music, and, we're really proud of the events that we do. We are part of the Endeavor companies, and Endeavor is one of the largest entertainment companies in the world. They do events in 38 different countries, over 800 events a year. They own companies such as UFC, professional bull riding, Country Thunder, which are country music festivals in the Midwest and in Canada, as well. That's what we are a part of. So with that becomes a vast amount of technology abilities, and any type of planning operations that is done in over 38 countries. And, London, they host Winter Wonderland that is about 4 million people over 6 to 7 weeks. I do want to say, let me give you a little bit of stats on country music fans. I've heard some of the testimonies that are in there. Country music fans arrive to these places intoxicated. They don't obey traffic laws. Evidently, they can't read big signs, have to rely on their GPS items. Those are not true, not factual. Country music fans are heartfelt and genuine, and we're very proud of the events that we do. Just some stats, 85% of country music fans own a home. Their average household income is $85,000. As far as us, I take a lot of pride that the festival itself has held its own liquor license for the last several years. You cannot do that if you are not responsible in serving alcohol. We take that very seriously. And I would also like to comment that Commissioner Nyquist congratulated us in the 2016 and 17 debriefings in public forum on what a great event. There's also some comment in there that we are there weeks and weeks setting up. I will tell you we have 2 other events the very end of July. We have one, Country Crossings, that is in Central Point, Oregon, and we have Mountain Home Country Music Festival that is in Idaho. My staff would love to be able to have weeks and weeks. That is not what happens. We finish at the end of July, and it takes us about a week to load in the event and a week to clean up the event. Opposing counsel has suggested that we are there for, again, weeks and weeks, and that is merely not the case. I would say in our earlier years,
Just finish your thought.
in our earlier years, it did take us longer, but we have grown and prospered a lot since then, and that is not the case. I would like to make one comment about the 60,000, Madam Chair, if you would allow me to.
Well, you've exceeded your 3 minutes, so I don't think that we can do that. I'm sorry.
Okay.
Thank you. Okay, so now we're going to move to the opponents. And I'm back on the first page. Brogan Oswald. You here? Is that you? Yes, ma'am. Okay. George Meyer. Is George Meyer here? Yes. Great, okay. No, that's all right. And then Gabrielle Whitaker, Gabriel, do you want to testify? Okay. And Dina Jensen, you want to testify? Okay, great. So these two are up. You'll be on deck next, okay? Okay, so let's start quickly, please.
Sorry, ma'am.
Thank you.
And he's got a handout of the same map for you. So
Okay, your 3 minutes has already started, so.
Okay.
All right.
Well, I just wanted to address, my name is Brogan Oswald to start, and thank you for your time. There's been some testimony earlier talking about why we have our fields that are laid out further away. And on these maps, it will kind of explain, it'll show that why we have those on there is because our headquarters are on these maps as well, everywhere where you see a star. And that is because, you know, during these seasons, we bring everything back to our headquarters. Everything we do on these fields, no matter what county they're in, wherever they're at, everything comes back to these headquarters every single day. And so we have those maps up on there, and we have another map underneath that that is smaller for the general area. And yeah, as I stated, my name is Brogan Oswald, and my wife Suzanne and I own and operate Oswald Farms off of Talbot Road. I'm here today to speak in opposition of the Willamette Country Music Festival moving to the neighboring EFU ground. We all know that there's been a lot and will be a lot of emotional and passionate testimony today in support of and in opposition of the music festival. I understand wanting to raise money in the Jefferson School District. I get the excitement for the local businesses hoping for an economical boost. But at the end of the day, this hearing is about the criteria set forth by state statute and Marion County Code for a mass gathering and conditional use permit. For more than 4 decades, Oregon has maintained a strong policy to protect farmland. The policy was adopted by the state legislature in 1973. And being a young, growing farm, it's these EFU laws and ordinance that give us the confidence to harvest, to invest, and continue to grow our farm in Oregon. The first criteria for the application that requires a conditional use permit on EFU ground in Marion County is that the use will not force a significant change in or significantly increase the cost of accepted farm or forest practices. Now, the word significant, by definition, means sufficiently great or important to be worthy of attention or noteworthy. Now, an increased cost amount that might not be noteworthy to Mr. Reader may be the difference between our farm making a profit or taking a loss. We operate on small profit margins farming. So who is to say what is considered significant to Oswald Farms may not be significant to Santee Ann Farms or vice versa? I've also heard a lot about how the local farmers in a related area are lying and inflating the number of impacted farms. Their argument for this is that several of the farms are family members utilizing the same headquarters. Just because we operate out of the same headquarters does not make our tax ID numbers any less different. We all have our own separate taxes and businesses, and we all operate out of our own pockets. It's like saying Bi-Mart is the same business as Joann's Fabrics in Albany because they share the same parking lot. And with that being said, if I have a delay getting my crop to harvest and Mother Nature decides to rain, then Oswald Farms eats that loss. Not GM Meyer Farms and not Blue Lace Farms just because we share the same driveway.
Time's up.
Thank you, Madam Chair.
Thank you. George Meyer. So why don't you start talking and you're, right, and we can have you, okay, very good.
For the record, my name is George Meyer. I live at 13274 Marlette Road, Jefferson, Oregon. I am a co-owner of GM Meyer Farms, LLC. I am opposed to the move of Willamette Country Music Festival to the Jefferson area. I have testified at prior hearings, gatherings, regarding a conditional use application. I'm a proud fourth-generation farmer in the Talbot area. We farm approximately 2,000 acres of high-value, mostly irrigated land in New Jefferson and the surrounding area. We grow turf-type tall fescue, perennial ryegrass, straw export, turf ryegrass and forage, and green beans and white clover and hazelnuts. The main farm headquarters is at 2535 Talbot Road. We have been in that location for 41 years. One of the main criticisms that we have received is that we are being dishonest with our harvest timeline, but in all reality, it is determined by Mother Nature. There are many different types of grasses, seed varieties. They all take different amounts of heat units to reach maturity to the point they can be harvested. Annual ryegrass is typically the first grass variety to be cut. The Grosses are possibly the only annual ryegrass farmers in the area. The majority of the farmers grow different varieties of grass seed other than annual ryegrass, mature later in the season. Our farm, we cut fescue, turf perennial, forage perennial, clover, and then we harvest the beans. The beans can be harvested from the 1st of July all the way until September, depending on planting dates. The cannery harvests green beans on a very tight schedule, and if they are delayed or being able to get their pickers to the field, they can choose to bypass. To stay on schedule with other farms, they would be a catastrophic loss to us if they bypassed us. If the Willamette Country Music Festival moves to the Jefferson area, it would cost a significant burden to the farming operation. We would roughly cost $150,000 in expenses, and that includes the cost of leasing 2 combines, 4 trucks, service vehicle, mobile mechanic, additional employees, 24-hour service, and irrigation trucks. In the handout you received on page 2, the potential crop losses involved not being able to irrigate the fields, harvest, potential rain damage on crops, hiring security, headquarters, and adjacent land next to the concert venue, employee wage losses.
Just finish your sentence. Go ahead and finish your sentence.
Basically, I'm opposed to this, and it's going to cost the farmers on that map right there basically $1 million.
Thank you. So Gabrielle Whitaker, is that right? And Dina Jensen, come on up. Niels Jensen.
He had to leave, but he's opposed to it.
Okay, thank you. Wes Pilcher, still here? You want to speak? Great, okay, so you'll be up after Dina. Thank you, go ahead.
Hello, my name is Gabrielle Whitaker of J2 Farms Incorporated, and I am a farmer who lives and farms in the Talbot Jefferson area. All of my farms are either close to the proposed festival site or along the proposed traffic routes. I'm a 4th-generation farmer who farms my own ground, and I also work for my family's farming business. There are 3 crops that I grow that would be negatively impacted by the Country Music Festival presence in Jefferson. These crops will be harvested and processed during the festival dates. I have submitted a letter with the potential economic loss of these crops. It is my understanding that one of the 5 criteria to review a conditional use permit is that the use will not force a significant change in or significantly increase costs of accepted farmer forest practices. We harvest peppermint that is started to be harvested at the beginning of August and can go until the end of August, depending on Mother Nature. Peppermint must be harvested at the correct bloom percentage, or the plant produces a chemical called methylpherine. Once this chemical is in the plant, there is no way to take it out. When our buyers test the oil we produce, if there are high levels of methylpherine, the oil can be rejected or taken a very discounted rate. The way we avoid this chemical is to operate 5 to 6 mint trucks hauling product to and from the field. Including our peppermint truck traffic, we also have harvesting equipment that's 16 feet wide, irrigation crews, and regular transportation activity. If our harvest equipment or trucks hauling product are delayed, our costs increase significantly. The statement talked about our peppermint harvest and many other farming operations like they were all the same. If one farmer only grows grass seed, this does not mean that all the other farmers also only grow grass seed. Even between varieties of grass seed, there are different planting dates, harvest dates, maturity dates, and input requirements. Everyone operates differently. The economic losses that this event would cause are something that must be considered as the law addresses this. Would you please consider the negative financial impact this event will have on my livelihood and my family and deny this application? Thank you.
Thank you. Dina?
Hello,
pull the microphone way up. You got to bite it. Thank you.
Hello.
There you go.
My name is Dina Jensen, and I farm on Talbot Road and throughout the Jefferson area. All of my fields are directly along the proposed traffic routes and or very close to the proposed festival sites. I raise 3 crops that will greatly be affected by this Willamette Country Music Festival. Most of the crops I grow are contracted, which means if I do not produce the best quality or if something happens and the crop is somehow damaged, I will lose my contracts. Contracts are essentially my way to make a living. Contracts are very hard to get and sometimes are passed down from generation to generation. I'm opposed to the Country Music Festival because of the devastating financial impact this event would cause my business. I have anywhere from $300 to $1,500 per acre invested in growing crop. So if I'm not able to harvest or if the crops get ruined, I do not just lose income. I would be going backwards financially and would not be able to recover. There are 5 crops that I would love to grow in the future. But if this festival moves to Jefferson, it would cause unnecessary challenge to grow them because they are harvested during this event. Some of these crops my family has grown for 4 generations. I do not think that the Country Music Festival should be able to limit what I can grow on my land, thus affecting my income for years to come. During this festival, I'm not only harvesting, I have to be irrigating, working ground, mouse baiting, and hauling straw. And every year will be different. One year I may have beans that desperately need water, and the next I may have mint being harvested in the same field. There is no way to know what will be planted in which field. Crop rotation is essential to my farming practice. I would like to point out that it worked in Brownsville because most of the farming is dry land and annual ryegrass or other dry land grasses. And they are harvested by the end of July. But here in Jefferson, there are many crops that are not harvested until the middle to end of August. The landowners of this proposed venue commented to the public the amount of trips our mint trucks take daily, but yet they do not grow peppermint in Jefferson. Every farm does things differently. One farmer cannot generalize the surrounding farming practices. And I don't know one farmer that even works his ground the same.
Thank you. So Wes Pilcher, Laurel Hines, you're next, and then Roger Kay. I don't even have to ask if you two want to talk, because, oh, you do. Laurel, come on up. And then
My
Roger,
name
you'll
is
be up
Wes
next.
Pilcher, third-generation farmer. My cropland that is affected by this is right here in the blue.
Hey, you're gonna, we can't pick you up without the microphone, so we need you to speak.
The blue on the map, if you can see that.
Right, and we
and
have
the
a
star
we have a
within the
code here.
blue is my headquarters.
Great.
If the proposed traffic routes are along 99E, I have fields that I cannot get to if there's an impasse because of an accident. And we've seen over the years that when there's an accident on I-5, which runs directly between me and the proposed event, all of the traffic routes around to 99E. I cannot conceive there's any way that this event can happen without detrimental impacts to all of us that live on 99E. I wholeheartedly agree with the testimony of the Jensen girls. I grow the same crops as they do, peppermint, green beans, and other crops that are also harvested within the time frame of the proposed festival. The economic impact to me is easily $10,000 if I can't get those crops harvested on time. I also represent the Sydney Irrigation Cooperative. I'm on the board of directors for that, and I am very concerned about possible pollution by 30,000 people crossing over our ditch. That's all I have. Thank you.
Thank you very much. Laurel? And Roger, would you come up, please?
My name is Laurel Hines, and I live in Spring Lake Estates, which is adjacent to the Ankeny Wildlife Refuge and along the route for the festival. And my main objection to this is that I believe that the festival poses serious risks to the wooded, dense rural communities that are along the routes where people will come with their GPS, and also is along the route that the festival has indicated that they are going to be directing traffic to avoid backups on I-5. So from my understanding, it will be coming up Ankeny Road, Ankeny Hill Road, and also there will be lots of traffic coming from Salem down Liberty Road south. This endangers far more health and safety risk than the former location in Brownsville. I visited the Brownsville area with Roger. We met with a farmer there, and it's much flatter, not as wooded. This also violates the Marion County Comprehensive Plan sections in section Roman numeral 2H on fish and wildlife and natural areas due to the location next to and traffic through the Ankeny Refuge. I was very happy to see the submission by the Northwest Environmental Defense Center attorney with the endangered species attention concerning the streaked horned lark. And I hope that commissioners read that letter because it's very important from their attorney. And I believe that the streaked horned lark may become the spotted owl in this case if it goes to appeals. Spring Lake Estates has 97 properties, about 93 homes in those properties. It's heavily wooded and brushy. There's only 2 access routes, one on Ankeny Hill Road and one on Liberty Road, and I've given you all a map to show where these are located. Stonecrest Hill homes have, I think, about 50, and they only have 1 access. So 30,000 people, the size of a medium city, flooding in cars and camper vehicles to the festival for 3 or 4 days from all directions is going to create serious risks to the community. Not only with wildfires, with people in party mode, not being aware of the dangers to our community, but also that the roads are curvy, hilly, very wooded, very brushy, and an inadvertent cigarette or a car crash could create the kind of devastation that we saw in California last year with whole communities, whole suburbs being burnt to the ground. And that's what our community is so worried about. We also will be trapped in our homes. So I have provided excerpts that in the handouts you got to the Marion County Comprehensive Plan.
Right, we have those.
Okay, thank you. I hope you consider the health and safety risks to our communities.
Good morning, Commissioners. My name is Roger Kay, current president of Friends of Marion County. We submitted numerous testimony at several times throughout this process, going back from December all the way till just recently last week. And I've presented 4 additional pages to supplement our earlier testimony. Again, one thing I do want to point out, rather than read this entire message, is that the event will exceed the time of 120 hours. As the applicant says, it will not. However, I attach an exhibit which indicates activity on the property for more than 3 weeks, and during that time, the farmland is unavailable for production. So that's another factor to consider. The impact on the farmland itself at which the festival is going to take place. They cannot guarantee the attendance because basically they issue tickets for people to enter the venue at the main event area, and they have to pass security. But people that come into the venue are also people who are going to be coming into the parking areas. And these parking areas are not controlled as the main venue ticketing is, but these people in the parking area are to be considered along with the people in the venue. So when we talk about more than 30,000 people will be at the venue, we're talking about the parking areas, and that is not under the strict control as is present at the venue. Again, there's been testimony from farmers about potential losses, and no one's really addressed the water policy in terms of the health division, and it specifies 12 gallons per person per day, plus an equal amount in reserve. This is 2.2 acre feet. You can't imagine how much 720,000 gallons space that would take. Threat to public safety. I've listed several things at the back, some items from KATU TV, and the applicant installed a prohibition in 2013 of minors in possession, and in 2015 there are 18, 2016 there are 51. So the actual cases of minors in possession increased over that time. And then there's the issue of the Sydney Titch, which I don't want to really go into. I've submitted testimony about that. And then my final issue is a summary of legal issues. You have to deny the permit because the outdoor mass gathering, because there's no legal access over the ditch. The traffic plan is inadequate and has not been approved. And the county can require a conditional use according to state law and the county code, which, by the way, has been adopted by DLCD in October of 17. So it is law in the county, and it's adopted and in the record from DLCD. Thank you.
Brian Krebs, here. Want to speak? Great, okay, you're up next. Audrey Roshan, okay. And then Dustin, you'll be right after Audrey. Be sure to state your name first, thank you.
Sorry. Good morning, my name is Brian Krebs, and I'm here representing Santiam Farms Incorporated. I oppose the conditional use permit and outdoor mass gathering application. My farm acres are represented by the color green on this map, and as you can see, I farm two predominant areas, the Talbot Road, Buena Vista area, and also east of Independence on River Road. The county roads between these two areas are winding two-lane roads with a railroad underpass that has a height restriction to 10 feet, 11 inches. We travel this road many times a day with both people and equipment, usually encountering no more than 2 or 3 cars, if any at all. The main concern I have regarding the traffic plan submitted by the festival is how it will interfere with our daily workflow, both between farm locations and from field to field with employees and equipment. The GPS technology attendees will follow the path of least resistance to and from the venue, making it impossible to travel these roads with modern farm equipment at the same time as music festival attendees. Some of the work activities that take place during the proposed festival weekend include grass straw baling, irrigation of grass fields, and tillage of harvested fields in preparation for planting tall fescue. Grass straw baling usually ends several days after grass seed harvest. The financial threat regarding grass straw is a rain event that will reduce quality and thus a reduction in price on the export market. I've included 2017 crop beer hauling tonnage and dates to reflect this activity during the proposed weekend. Employees who are responsible for irrigation will make 2 to 3 trips daily to each field to move or monitor irrigation equipment. They may also be responsible for equipment at both the Talbot location and the Independence location, requiring travel along Buena Vista Road, Sydney Road, and Riverside Drive. Irrigation equipment typically runs on a 22.5-hour cycle. This gives us an hour and a half each day to reset the equipment, and these windows are staggered throughout the day. Any increase in travel time for these employees will make it impossible to complete this work in a timely manner. Additional man hours at additional costs will be required to avoid this delay. The planning window for tall fescue to maximize potential yield in the first year is August 25th to September 5th. Planting after September 5th will have a reduced yield this first year. We make every effort to plant as early as possible, weather permitting. A delay in tillage would cause a delay in optimum planting date, thus causing an economic loss. Now imagine a large tractor pulling over-width tillage equipment on these narrow roads, moving in an opposite direction of festival traffic. It will be virtually impossible and the risk for an accident extremely high. As stated in earlier testimony, Our farm will be harvesting crops during the weekend of the proposed festival, which also potentially cause increased travel times to deliver seed and vegetable crops, but also cause a downstream increased risk to harvested acres occurring in the days after the festival. Green beans harvested starts around July 10th and finishes around the first week of September. The harvest schedule for beans is based on a planting schedule made by Norpac Foods. It is almost impossible to predict harvest date for a particular planting. I've included delivery information for beans harvested in 2016 and 2017 to reflect this.
Thank you very much. Audrey?
Hi, my name is Audrey Roshine, for the record. Thank you for taking the time to hear of all of our concerns about the Willamette Country Music Festival relocating to Jefferson, more importantly to the Talbot area next to the Ankeny Wildlife Refuge. I am testifying today to oppose the mass gathering permit and the conditional use submitted by Jimmy Gross and Willamette Country Music Festival. My husband and I own the property that is conjoining the proposed camping site. As of right now, we have it planted to turf-type tall fescue. We also have 2 other fields we farmed that are not located in the Talbot area. One is located on Highway 34, planted to turf-type tall fescue, and the other one is located on Higbee Road, just south of the Sandiam Rest area, planted to hazelnut trees. Along with our farm, I work full-time for my parents' farming operation. Their farm headquarters is located at 2535 Talbot Road South. I report to work every day during the summer no later than 7 a.m., and I leave any time between 5 and 9 p.m. depending on my family's needs. I have 2 young children that attend daycare during the day. The traffic backup and delays will pose a problem with me getting to work in the mornings and home at night. We purchased a tractor to help with harvest. Our tractor runs a 30-foot flail. After we combine the grass seed for seed, the straw is baled for export. We then use our tractor to flail the remaining stubble and straw left behind. When I called my insurance agent to ask if I could increase my limited liability insurance to $10 million, his first response was to laugh and ask, why do you need such a high policy when your current assets do not equal that much? He explained that he could get me a $5 million policy, but anything higher would have to go through another company for approval. I would also need to prove why I needed such a high policy. If I get the approval, it will cost our farm an additional $8,400. That's on top of our current policy. Worst case scenario, my flail, or for that matter, any piece of equipment that starts a fire on my property adjoins to the Willamette Country Music Festival's campground, it travels over onto the Grosses' property and catches a few RV or tents on fire. What happens if there's someone inside who gets trapped and doesn't make it out alive? There's not enough insurance to cover an accident like that. My husband and I have worked very hard to get where we are today. I don't want a catastrophic event to take away everything we have worked hard for. Every one of these extra costs will cut into my profits. I am projecting that these extra costs will be around $20,000. We don't have the extra money in our budget to pay for these added costs. In the conditional use application, one of the criteria was that it's not supposed to create significant financial impact to other EFU and farming practices. Farming is weather related. Everything we do on our farm is dictated by the weather. While we are harvesting our grass seed, we wait until it's at least 70 degrees outside in order to get the best harvesting results. Our start time changes every day depending on the weather. As an Oregonian, we know that the rain can be in the forecast. These storms are known for dropping inches of rain at a time. In the mass gathering criteria required by the state of Oregon in 333-039-0055, it states there needs to be roads of all weather construction. These roads needed to be graded. In section 3, ungraveled dirt roads are not considered all weather roads. Can I finish the rest of that? I'm just right here.
Well, if you want to submit that, we can actually have it in the record, and it will be, have you already submitted that letter?
I have not.
Okay, why don't you go ahead and submit it to legal counsel, and then everything else that you didn't have time to say will be part of the record. Thank you. And Dustin, you are next, and then Harold Miller, are you here? Harold Miller?
Thank you.
Suzanne Oswald, would you like to testify? Okay, you'll be next then after Harold Miller. And then Rick Nye would be on deck next. Is Rick Nye here? Would you want to testify? Great, all right. Go ahead and start, say your name.
My name is Dustin Roshine, for the record. Board of Commissioners, thank you for taking the time to hear my concerns about the Willamette Country Music Festival. I'm here to testify to oppose the permit. My wife and I own Blue Lace Farms, and we farm the acreage next to the proposed camping site. As a farmer, my wife and I have to wait all year long until June, July, and August to harvest our crops. We work very hard all year long so that our crops can produce enough to run the farm the next year, and so on and so on. The roads to be used for this permit are no means sufficient to handle farm equipment and 30,000 people at the same time. Our tractor that we use to pull a flail chopper is 11 foot 6 inches wide. The chopper, when folded up in transport mode, is over 13 feet wide. When passing these concert goers down Talbot, Wintel, Marlatt Road, it's going to create a bad situation. I don't know of a person that would drive their pickup and house trailer, RV trailer, into the ditch to let the tractor and chopper pass by. I have provided pictures showing what a combine and a pickup look like passing each other on Talbot and Marlatt roads. I've also provided pictures for reference when tractors and cars have collisions. Aside from farming, my wife and I am a co-owner of Farmland Tractor Supply in Tangent, Oregon. Our business is a tractor salvage yard. On a regular basis in summer months, we go out and retrieve these tractors that have been in accidents. Thank you.
Thank you. Suzanne.
Hi, good morning. I'm Suzanne Oswald with Oswald Farms, and I just wanted to thank you for the opportunity to speak today. I'm opposed to Willamette Country Music Festival moving to Jefferson. As my husband Brogan Oswald has stated earlier, the potential impacts on not only our farm but the neighboring EFU farm around is undeniable. I fully support the findings of the hearings officer's recommendation to the board for denial. Oregon and Marion County have done a great job of protecting our agricultural land to preserve it for generations to come. It would be a sad day to see the law and the codes bent to allow EFU farmland to be used for a music concert, and in doing so, open the door to future intrusions and the loss of crucial farmland. And then I just wanted to set the record straight regarding the testimony that the Gross family submitted on June 12th, stating that the Meyer, Oswald, and Rothschein family attended the concert last year. This is absolutely false. I'm the only family member who has ever attended the festival in Brownsville. The last time I attended the festival was in 2014. At this time, I was not employed by the farm. I feel that it is important to clear this up. We are extremely busy at this time of year, and as we have stated in our previous testimony. And I just want to thank you for your consideration in this matter.
Thank you. Okay, well, next we have Kathleen Bobbio. Okay. All right, you can't speak if you don't wish to speak. So if you want to say anything, you have to come over here and speak in a microphone. Okay, Michelle Morin? Here?
She had to leave, she also was.
Okay, thank you. So now I'm on page 4, James, okay, great, thank you. Allison Miller? There you go, thank you. And, let's see, Rick, okay, so you're up next, and then Allison. And then Jonathan, are you speaking? Okay, so you'll be up after Allison. So Rick is next, I believe. Who? Is that, you're Rick Nye, is that right?
Yes, I am.
Yeah, okay,
Yes.
you're next.
So my name is Rick Nyes. I work for Greenlight Engineering. I'm a registered professional engineer and was hired to analyze the transportation impacts of the project. I want to start out by saying this is very unusual to be at this situation at this point in time and not have an approved traffic impact study. Normally at this point when you're about to make a decision on an application, you have an approved traffic impact study, or at least something that all agencies agree upon. As the planner mentioned this morning, again, the TIA is incomplete, which means there will likely be future TIA submissions, traffic impact study submissions. So in my opinion, the approval of this application is really not timely. It's not providing, if you close the record today or in the near term, it's not providing the public with that opportunity to actually review the traffic impacts of the project. Most people probably aren't aware that the traffic routing plan has actually changed within the past 2 weeks, and it was a major change to the traffic routing. And that traffic routing was not really analyzed to the level of detail that the previous traffic routing was, which was also had many emissions included. There are a number of Marion County staff requirements that have not been met in terms of what the traffic study should include. Probably the most prominent of those emissions is vehicle queuing during the peak and off-peak periods. None of the traffic impact studies evaluate the traffic queuing at all. The applicant does not know how long those traffic queues will be, either during the ingress or the egress periods. the applicant has proposed mitigation at several intersections that largely include flagging. They don't know what the impacts of those flag operations will be. They don't know how long those queues will be. They don't know if the queues will extend all the way into I-5 or not. That was a very clear requirement of Marion County's initial scoping, was for the applicant to evaluate queuing during the off-peak and peak periods, and they still have failed to do that. As of June 11th, Marion County submitted a 5-page critique of the detailed traffic control plan. Again, we're not even close to having a traffic control plan that's approvable. There's not substantial evidence in the record that establishes how the intersections will operate, either with the applicant's proposed mitigation or without it. In fact, the applicant did not even collect traffic counts at the study intersections during the egress period of the application. They have it during the ingress period, during a period in January, but not during the summer and not during the egress period. So there's substantial omissions in the traffic impact study. The applicant also suggests now that local traffic will somehow be allowed to travel on a route west at Ankeny Hill Road, whereas the remainder of the festival traffic will head east around and take the several mile long loop. It's really unclear how that traffic will be differentiated. How will local traffic be separated from the rest of the festival going traffic? Thank you.
Thank you. Allison?
My name is Allison Miller. I have my master's in ecology, and I own and operate a permaculture farm that's been in our family since 1915. I am talking about traffic of a different kind. According to the Portland Police Department and the Oregon Human Trafficking Task Force, reference Article 2, Portland, Oregon is one of the nation's primary cities for sex trafficking, particularly children. This is due to the Columbia Gorge waterways and the access to I-5, which approved would run right by the Bi-Mart Willamette Valley Music Festival. Portland PD further emphasized to me that the I-5 is one of the nation's main arteries for human trafficking. Please reference Article 5 and 6. Tennessee, the heart of country music, is now experiencing an increase in sex trafficking at music festivals and rural settings. In terms of the Tennessee FBI, and the state of Tennessee has indicated that the United States, on average, every 2 minutes a child is bought or sold for sex. The average age is 13. Human trafficking is the second fastest growing criminal industry next to the drug trafficking. According to Detective Keith Bigford of the Oregon Humane Trafficking Traffic Force, phone number 1-503-988-0400, sex trafficking is a crime hidden in plain sight, hidden behind the crowds, activities, and entertainment. Stopping the crime is nearly impossible. What is the perfect recipe for human trafficking events? Large base of youthful volunteers, or any volunteer that is economically or socially vulnerable. Children ages 14 through 19 are most sought after. Children from economically vulnerable communities and or broken, troubled families. Low police profile and coverage. Vulnerable settings, isolation, such as large tracts of land that Ankeny and the farmers' adjacent fields offer. Accessible access in and out of the facilities, such as the I-5 and easy access to Ankeny. Large tracts of empty, quiet land. Large crowds, alcohol, and drugs. I am dismayed that the school officials, families, and public officials have not considered the ideal setting for sex trafficking risks at the Bi-Mart Willamette Valley Music Festival. It seems to me no amount of money is worth risking one child's exposure to this horrific growing issue of sex trafficking or the individuals brought in for illegal sex. It further seems to me that this kind of carnage is not worth profiting the proprietor of the event or any amount of donations to the schools which are charged for the care of children's well-being. It further seems again to me the money from the Bi-Mart Willamette Valley Music Festival event is a poor investment for school and child safety and is also not a morally sustainable way for which to build a community or economy. Quoted in Article 1, just like everyone, traffickers love festivals. They love these events because festivals open up an opportunity for traffickers and Johns to buy, sell, and exploit women, children, and man for sex slavery. Big events make it easy for
Yeah, just complete your sentence.
Big events make it easy for children, women, and men to become victims of sex trafficking because traffickers can lead them away in the midst of a crowd or large open lands. And for these reasons and many more, I oppose the music festival. Thank you.
Thank you, and we do have your written testimony
Yes.
for whatever you were not able to complete. So Jonathan, you're next. Dylan Wells, you're up. And then after that, we have Rick Briley. Is Rick here? Would you like to testify? Yes, okay. So you'll be after Dylan. And then Holly DeJager. Don't want to testify. Dennis Person. You do want to testify. All right, so Dennis, you and Rick will be up after these two. Jonathan.
Chair Carlson, Commissioner Bertano, Commissioner Cameron. For the record, my name is Jonathan Sandow. I'm here on behalf of the Oregon Farm Bureau, who represents over 7,000 farming families and 60,000 individuals around the state. Thank you for allowing us to testify. We have submitted a comprehensive written testimony, so I'll not go over that verbatim. I will just highlight a few key points here today. First, we agree with the hearing officer's findings regarding the permits. Second, Farm Bureau shares the concerns that was referenced earlier by Lynn County and by many people here today about the impacts on the land and the neighboring farms. Second, we have numerous farmers in the region who have submitted written testimony who couldn't be here today, and also who you've heard from just recently. And Farm Bureau stands in support of their opposition for those technical reasons that they provided. And finally, we recognize the work that has gone into the planning. We recognize the economic benefit that this could bring to the county. However, citing a festival of a minimum of 30,000 attendees in active farm country, it's simply inappropriate. So Farm Bureau urges the denial of this application. Thank you.
Thank you. Dylan?
Dylan Wells, representing, Marion County Farm Bureau. We have 600 and some odd voting and supporting members in Marion County. Again, we have submitted a written testimony, and our main points are that the impact on the local farmers there is going to be significant, and we are in opposition of this, and we also believe that liability issues for the neighboring farms is going to be significant, and we do not wish for that to be put on these local farm families. So with that, that's all I have for you.
Thank you very much. Rick Briley, Dennis Pearson, and then Linda Peterson. Are you still here? Want to testify, Linda Peterson? You do. Okay, great. You'll be up after Dennis Pearson. So Rick, are you Rick?
I'm Rick Briley, and I'm not a farmer. I'm just a concerned citizen from the Talbot area. I built a house out there 38 years ago, and during this time I've been a volunteer with the Talbot Station 640, located in the Talbot community. I was in there for 18 years. I ultimately was promoted to volunteer chief of that station. And during my time as chief, we had a total of 60 volunteers in the district, covering the whole 96 square miles. And approximately 44 were active members. And that was in 1998. And that year, I'll get to that in a minute. The number of volunteers has since decreased by roughly 50%, and they're receiving a third more calls than they did in 1998. And there's roughly 19 active volunteers in the whole district. And I believe it's safe to say that the fire department is maxed out. In 1998, I elected with my time, I needed to spend more time with my grandkids. I was starting to accumulate and stuff, and so I voluntarily retired myself from the fire service and did the 8 members of the Talbot Station. And at that time, they have not got another volunteer in that station in the last 20 years. So they're kind of maxed out. Because my understanding is Staten, Almsville, and Turner Fire Departments will be sending fire equipment to be used in the Talbot area except for mutual aid assistance. Renee Gonzalez, a member of the Board of Jefferson Rural Fire Protection, stated that the Jefferson trucks will only be manned by Jefferson paid staff and volunteers. I'm just kind of concerned about getting adequate first aid to our other citizens. I have the greatest respect for local firefighters. I know the sacrifices these men and women make for their communities, and I understand how hard it is this day and age to get volunteers. How do you think it is possible for that fire department to take on another 30,000 more residents, even if it is for 4 days? Or that's a lot of people. Thank you very much.
Thank you. Dennis.
Dennis Person, 1878 Talbot Road. My career has put me in charge of high exposure, high risk project downtown areas and construction. I think there needs to be a real particular attention to that traffic impact analysis on this project, I-5 corridor and the impact of that. I did a simple count a week ago on Tuesday from 10 a.m. to 11 a.m. and there were 653 tractor-trailer rigs going down that freeway. Now, this does not include all the service vehicles, etc. So the financial impact alone on lost revenue and commerce will, I calculated, like I said, $19,000 an hour for just semi-rigs. Simple numbers will be immense on this project. So it does have a huge impact on that I-5 corridor. No less the impact of the ambulance services coming up from the south to bring patients to that Salem Hospital area and to deliberately plug up that interstate highway. I can't see how you would do that. As far as some of the other issues here brought up by the attorney, it was interesting that 4375, unless defined by the county on the mass gathering, I find it, I would hate to see the commissioners lose authority in this area, and you represent the citizens of Marion County and not a group that is interested in making money on EFU property and state goals concerning EFU property to protect that property. Appreciate it. Thank you.
Thank you. Linda Peterson and then Kathleen Carl, you're next. You still here? Yes, so come on up. And then Ray Temple, are you here? Want to speak? Yes, okay, so you'll be after Kathleen. Linda, state your name for the record, please, and bring the microphone, pull it towards you. Okay. Pull. There you go. Thank you.
All right. My name is Linda Peterson, and I live on Friendship Avenue, just off of Liberty Road.
Need to pull it closer. I can hardly hear you.
Okay.
Thank you.
Anyway, what I'd like to, there seems to be two issues that I've heard in this hearing to be important. One of them was some people will make some money, and the other one is we've had this festival in Brownsville and everything worked out pretty well. Well, the first issue, the money issue, money is important, and I like to see our people that run their businesses profit. But some things are more important, and safety, I think, is. And secondly, Brownsville, I've been to Brownsville, and it's way out in a rural area, and to compare it to a large metro area and with I-5 and this narrow roads and stuff that's in that area. I live fairly close to the refuge, so I'm very familiar with the area. That consists of a lot of the paved roads are very narrow, and they have deep ditches on both sides. And then there's the issue of the gravel roads. And to schedule and hold a festival of this size in that area is a guaranteed recipe for disaster. In addition to the narrow roads, there's an unsignaled railroad crossing that I would be concerned with. Also, that this time of the year and a little bit later, we hear sirens all the time from the fire department going out on grass fires and brush fires. So that if somebody has a heart attack or there's a serious accident, and these roads and the freeway are tied up with traffic, someone could lose their life. And that's about all I have to say.
Thank you. Thank you for waiting so long, all of you that have been waiting. Kathleen?
Chairperson Carlson, Commissioner Brentano, and Commissioner Cameron. My name's Kathleen Carl. I'm a co-owner of an almost 500-acre farm in Hubbard, Oregon, which now has the 5th generation living on it. I'm testifying against this because I'm a big believer in our farm use laws and protecting agriculture, which is a $500 million industry in Marion County. I'm sure you've heard the saying, make hay while the sun shines, and that's just not saying it's the truth. But underlying that saying is not just weather, but timing. And timing is of utmost importance to farming. When the crop is ready, you have to harvest it. And I think this festival will interfere with farmers working in their fields and transporting goods, and you can't just say, oh, I'll just take off 4 days, and because those might be the days that the crops are ready. So I believe that this will force significant changes in farming and therefore it shouldn't be approved. For the first year on our farm since I was a kid, hoeing endless rows of corn, we're growing corn on our farm, and it's grown with a contract. And I noticed a young woman earlier testified about how it's important that you get that crop when the processors want it. And again, I think having the festival there could force significant changes in farming. So every year, Marion County Farm Board, I'm on the Marion County Farm Board, but I'm testifying as an individual. But we give money to sponsor radio ads about accommodating slow-moving farm vehicles. A few years ago, one of our board members was killed by somebody who didn't know how to accommodate that. And I think it's frightening that there'll be hundreds and thousands of people driving on the road and don't know how to drive around farm equipment. I don't believe that a music festival is a good use in the midst of EFU land. I believe that the conditional uses are there for a reason and that this could force significant changes. Whatever the music is, people who've had too much to drink and are enjoying themselves in such large groups easily disrespect boundaries, and those boundaries might be somebody's farm or somebody's pond. I think the risk to the traditional stakeholders and the risk to our farm use laws around this proposed festival are significant, and that you should deny it. And I ask that you not allow this festival. Thank you.
Thank you. So we have Ray Temple. I already called your name, right? So you're up now. And then Don Dean, are you here?
Don Dean can't believe he's also a Spring Lake Estates.
Thank you. Okay. Jan Jaskowski? Had to leave, okay. And Tim Jaskowski also had to leave? Yes, all right, thank you. And then Susan Lee Smith, are you here? All right, so you're our last testifier, so come on up. So Ray Temple, state your name for the record and give us your testimony.
Hi, I'm Ray Temple. I'm the president of the board of directors for the Salem Audubon Society. We're a bird conservation, nature education organization, and we partner with the Fish and Wildlife Service at Ankeny Refuge, where we're constructing a nature center that we expect to open next summer. Thank you for the opportunity to comment on the matter at hand. You have a written testimony from me regarding our concerns about adverse impacts to our nature center project, as well as some impacts to wildlife. I'd like to make just a couple of comments without reiterating all of that. One is, in my 40 years of experience in natural resources, two things are very obvious. One of those is that forecasting impacts to wildlife from a variety of activities is a very uncertain science. We make mistakes. The other is in the history of environmental impact, the evaluations that tend to be made, tend to be lopsided because with developmental activity or whatever, there are economic activities that can be measured and quantified. The impacts to wildlife are usually uncertain, and the economic aspects of those impacts is really quite intangible. So these kinds of decisions tend to be lopsided. They tend to favor development. So my point in this is we will likely never know if there are wildlife impacts to Ankeny Refuge, to the wildlife there, if you approve this proposal. I think the right thing to do here in the face of uncertainty is to err on the side of avoiding potential impacts. Finally, something to bear in mind, please, as you consider the applicant's proposal. What you have in front of you, as I understand it, is a question relative to staging this festival in 2019. Whatever decision you make is going to carry well forward into the future past 2019. Whatever you decide here is going to set expectations and precedent that are going to be very hard to undo in the future. So I would urge you again to err on the side of uncertainty here and avoiding impact and avoiding setting precedent that may be difficult to undo down the road. Thank you very much.
Thank you, Commissioners. My name is Susan Leah Smith, and I have been a Marion County resident for 29 years, and I'm a fourth-generation Oregonian. I am a professor of law at Willamette University. I have specialized in natural resources and environmental law for the last 40 years. I speak in my personal capacity, not as representing the university. I'm familiar with all of the laws at issue in this case, and I've read the record compiled by the hearing officer in this case. It's my professional opinion that the hearing officer's recommendation to deny the permit is well-reasoned, well-founded in law, and the record fully supports the findings of facts reached by the hearing officer. First of all, under existing law, I believe that the permit must be denied. It's quite obvious to anyone that the proposed activity has no place in an exclusive farm use area, much less one in close proximity to the Ankeny National Wildlife Refuge. As to the issue of jurisdiction and the extent to which you have to have a conditional use permit, I would note that there's no support in the record whatsoever that this event will be less than 120 hours. The promoter herself just said it's going to take 2 weeks to set up and take down. If you take out the 4 days that are allowed for leeway for that under our ordinance, that means you have 10 days plus the event, unless my math is wrong, that's more than 120 hours. Second, you have unrebutted testimony in the record that there will be substantial, not just significant impacts on local farmers and farming practices and the land as well. You can't grant a permit under those circumstances. The last point I'd like to raise is that of salmon. There was a mention of the fact that there's a ditch with salmon habitat. The salmon impacts are troublesome. Really, the environmental consultant who talked about there being no fill missed the point. We're not talking about a federal permit here, nor a state fill permit. What we're talking about is the fact that sediment will go on top of salmon spawning habitat, and that is what kills salmon. You have plenty of reason to believe that there will be dust and erosion. I have one further point that I will submit in my written testimony.
Thank you very much. So that concludes the testimony. I'm not inclined to take anyone who hasn't signed up. If there's someone but I'm not a perfect person, so it's possible anyone that signed up that didn't get to testify. I try. All right, so I believe that now it's time for is it the applicant that makes the closing? We allowed rebuttal, but however, that was more because of the rebuttal, because we allowed the attorney so it was rebuttal to the attorney's testimony. So I do think that it's in order for the applicant to come up and just make some closing comments, and then staff, Brandon, why don't you come on up too? Are you coming up, Brandon? Okay. Are we good? Yeah.
Madam.
All right. And then, do we have a time limit on that, or you're? Right. And you'll be succinct, right,
Someone's phone?
Yes. Mr. Reader?
Yes.
Thank you.
Someone left their phone.
Madam Chair, Commissioners, thank you for your patience. Thank you for listening to everyone's testimony, and I appreciate the civility that has been here today, as this is an emotional issue. And I bring that up because it is an emotional issue, and because there are so many moving parts for these applications. There's 3 applications before you. The applicant stands by the testimony that I provided earlier today, which is that the outdoor mass gathering statute preempts the current Marion County Code provisions that we have discussed today. And I would encourage the board to look at the Marion County Code provisions and see if there are areas in which the board can make changes to the code so that it is reflective of the outdoor mass gathering statute. I would like to rebut very briefly the testimony of the last speaker, and I apologize, her name was Ms. Smith, wherein she said that there's no support in the record that the event will be less than 120 hours, and that is simply not true. We've provided substantial evidence in the record to show that the event will be less than 120 hours. The event is when there are 3,000 people on site. Again, as we've discussed, it's been discussed a lot that the setup and the takedown, it seems to be the issue. Now, if you were to include setup and takedown and cleanup, then perhaps if you consider that part of the outdoor mass gathering, then perhaps the opponents would have a point. The problem is that the statute doesn't allow that. And again, I would refer you to my February 21st, 2018 letter, where I exhaustively explain that point of law. In terms of the testimony that you've received regarding the TIA from, I believe it was Greenlight Engineering, I'm not a transportation engineer, just like the attorney for the Environmental Defense Council is not a biologist. But I do know in talking with the applicants, traffic consultants, Del Huntington and Joe Bessman, that in this particular case, when you're talking about a 5-day event with temporary use, that the typical TIA requirements, the traffic impact analysis requirements that were identified by the opponent's traffic consultant, those requirements are not a requirement of this CUP or, more importantly, the outdoor mass gathering. If you actually look at the outdoor mass gathering regulations, a TIA is not required. At my encouragement, the applicant hired these 2 professionals to do not only a TIA that would be appropriate for this proposal, but to also go the extra mile and to interview and talk with the farmers in the area who would speak to them. And that substantial testimony is in the record. It's in your traffic impact analysis, revised April 6, 2018. And there is significant text that discusses the farming practices in the area, not just for the folks that have testified, but the folks who have not testified. And it shows the potential impacts to those farmers. In addition to that, what we did was we went through an analysis to find out how we could mitigate those potential impacts, even though it's not required. We want to be a good neighbor. So how can we mitigate those impacts? And that is exhaustively detailed in the traffic impact analysis, and I would refer you to that as you make your determination. One last item that I would like to touch on is this idea that the application, or I'm sorry, that the event is going to have more than 30,000 people. We can't, repeating something over and over doesn't make it true. There are electronic wristbands that control how many people will show up on site. And the fact of the matter is originally there was a plan to have more than 30,000. Early on in the process, we made it clear that we are not seeking for 60,000 people, that the maximum will be 30,000. And it's controlled by a national platform whose reputation and business model is to make sure that that threshold is never exceeded. Why anybody would go to a music festival and hang out in the parking lot but not go into the venue is beyond me, but I think that's a red herring. So with that, I am available to answer any questions specifically regarding the law that is applicable that you're going to have to wrestle with. Thank you for your consideration.
Thank you, Mr. Reader. So I just have two quick questions. One is, you had mentioned at the outset in your comments that if the well becomes an issue as a permanent structure, you wouldn't even need to use the well. What is the status of the well? Is it there? Is it not there? Does it need to be done? Do you have a permit to actually dig a well there?
So, thank you, Madam Chair. The permit has been applied for, and we've received approval for the potable water well, and that's been received by the state. I think the issue at hand regarding the well is whether or not a permanent structure is allowed, and I understand.
Right, yeah, no, I don't want to go into all of that.
Yeah.
I just was curious because I was wondering whether the well was actually there when you said we wouldn't use it, and I had the impression from the writing that it was a well that you needed in concept, so I just wanted to clarify that.
Right, thank you. And to clarify, the well can be approved by the state without us ever using it. So just like if you had a residential house that was approved.
Right. Yeah, I understand that. I just was wondering what the status of the well was. And then has the traffic analysis been approved by ODOT? At the time of the hearings officer's report, there was a comment in there saying that it had not yet been reviewed or approved by ODOT. Do you have information on that?
Well, I would actually, if you don't mind, Madam Chair, I'd actually like to turn that question over to Dale Huntington, who is better able to answer your question.
Is that okay? All right, just really quick, because we've been here a long time.
Yes, thank you. As I mentioned in my testimony, there was a letter submitted by Keith Blair, the acting Region 2 ODOT traffic manager, and in that April 17 letter, he says that the revised traffic impact study of April 6th will adequately mitigate the traffic, and I don't have the memo right in front of me. It was part of a memo that we sent to you, I believe, dated June 16.
All right, thank you. This hearings officer report is dated June 7th, so I was just trying to figure out how the time frames worked, because it says they haven't responded to the new analysis as of June 7th, so that came out immediately after, on the 16th, is that what you said?
The memo.
Oh, you've got to be on a microphone, sorry. And it's not just for us to hear, it's the record is connected, the recording is connected to the microphone. So.
Thank you. The memo was posted to the Marion County website prior to the hearing officer recommendation, and so it may have been oversight or something she just missed.
Okay, I was just wanting to verify
Commissioner,
that part of
the hearings officer's recommendation includes testimony through April 20th.
Okay, all right, so the record was closed.
The record for the hearing that she held closed on April 20th.
All right, thank you. All right, I don't have any other questions for Mr. Reader, but do you have questions? Do you have questions, Commissioner?
No, I don't. Well, yeah, I guess I want to follow up on the question that I asked the opposing attorney earlier. Maybe I should do this. Is the question in my mind is the requirement of the conditional use permit. The question I asked was Lynn County in violation of land use laws, because he said that if we did this, we'd be in violation of land use laws, and I'd like your opinion on that, because his point was that we have a different code at Marion County than Lynn County does. And I'm going to ask staff to follow up on this particular question, because that's what I have in my mind.
So thank you, Commissioner. Mike Reeder for the record. I am not as familiar with the Lynn County Code as I am with the Marion County Code. So what I can tell you is that if you approve the outdoor mass gathering, as I have suggested under ORS 433-750, and you have the ability to make the determination that as a county board, you can approve the outdoor mass gathering without a conditional use permit and without looking to any local land use law. So you as the board have that authority, in fact, and I would argue you have that duty. If you decide that you believe that the conditional use permit is required, that a conditional use permit is required for an outdoor mass gathering permit, you could make that determination, and I believe that you would be within the law of the Marion County Code. But however, as I've explained, I believe that the Marion County Code as drafted is invalid.
Thank you.
Thank you very much. So Brandon, you have anything you want to add? And I've got one question for you.
Sure. Initially, I want to point out still that there are representatives from the County Public Works, County Sheriff, County Environmental Health, and the Jefferson Fire District here, in case you have questions about for them. Cindy Schmidt, County Engineer, and Tammy Robbins, Jefferson Fire District, do have some clarifying comments if the hearing rules will permit and the board would allow.
I think let's just see if we have questions that come up around that, because I'm not sure that information is going to, I know for my particular feelings, I'm not going to need that, but
okay.
If other commissioners are interested. So let me just first of all say, let me ask you my question, and then I have something I want to say. So do the math problem for me, 120 hours.
Yeah, I calculated that early. I based it.
And don't calculate it based on what you sent in like in December of 2017 or whatever. We had testimony here today that it was 1 week setup, 1 week after. And is it a 4 or a 5 day event? I was counting the days. It looked like it was 4.
4 days.
4 days, right, okay.
So the applicants provided with the application submittal a schedule of events that setting up the events to take down. So I used those hours initially. And the setup time is 117 hours, which is probably less than a week, 124, about 5 days, 5.5 days. Setup time, 117 hours. And you subtract the 48 hours that the county allows for setup. That's 69 hours that count toward the total based on the setup time.
Okay, so explain to me, why is setup included in the time calculation?
Well, it actually isn't the way the county defines it. We consider a mass gathering any event with 3,000 or more people, regardless of the time.
All right, so the 3,000 or more people is the trigger for us?
That's the only
Even if it
trigger.
were less than 120 hours, for that's
Correct.
not the determining element?
State
All right,
law,
that's a good
ORS
clarification.
433 does not give a setup takedown time.
All right, okay.
And so the county has defined, so for a mass gathering between 750 and 3,000 people, the county defines it if it exceeds 120 hours, then that also triggers it to be a large gathering.
So it's not this plus that, it's an either or?
There's 3 options in county
Right,
code.
okay.
Over 3,000, between 750 and 3,000, and over 120 hours, or less than 750.
All right,
And I have to look up more details
okay.
on that.
So any other questions for Brandon on any aspect of anything we've heard today?
Yeah.
Yes.
Thank you, Madam Chair. So Brandon, the question that I have is, I'm going to ask it again. Was Lynn County in violation, in your opinion, was Lynn County in violation of land use laws when they went ahead and approved their music festival?
I looked at what Lynn County did some 6 months ago, and the recollection at this point is that their code follows state law, the 3,000, the 120 hours. And I also believe in what they adopted, they addressed the land use component in ORS 433-763, the compatibility with surrounding uses and cumulative impact. That's my recollection at this time.
Follow up if I may.
Sure.
So did they have a conditional use permit?
I don't believe they did.
Okay. So they interpreted, their code was different than our code as far as requiring a conditional use permit based on where we're at today.
Yes.
There is differences, as
There
was
are.
stated.
And actually, the ORS anticipates differences. In 433763, it says one of the requirements is to obtain any land use required. So it's not, doesn't say that it has to be land use, but depending on how jurisdictions enact that statute, there could be land use components.
Okay, thank you.
Anything else? All right, so anything else, Brandon, from your perspective? Yes.
I do, Madam Chair. Sorry. Brandon, this, again, one more question. So, what you've just said is we have, as Marion County, have probably a stricter component to this. So we've set ourselves up to have more control than potentially Lynn County did, just on enacting our code.
It does. Our code reflects there's differences in farming in Marion County than there are other counties, and it reflects that. But uniquely, I think in some ways our code does something in addition. It says you have to have a conditional use and look at the ability of the land to support the use and the impacts on neighboring uses, which actually mirrors the land use component in 433763, which you look at the impact on surrounding uses. And we also define in our code this kind of gathering with this over 3,000 people is limited in a time frame throughout the year. So the concept would be many properties, depending upon how many events you could have, but many properties could eventually qualify for events during some time of the year. And our code anticipates that by limiting it by the time frame, we mirror the cumulative impact concept, that if you've got everyone doing this, how many properties could be doing this, what would be the impact to the whole region? So in ways, our code mirrors what's in 433763 to ensure that it won't be so many events so often that there'll be an cumulative impact to the neighborhood, and there won't be impacts to neighboring properties.
Okay, you're going way too
Okay.
far. So, and the last thing I want to ask, and I'm not advocating for this, but is there something in our code that if we were to change that, we would be in the same position as Lynn County and not require a conditional use permit?
We could adopt time standards for, say, over 3,000 people, 120 hours, and our code could be defined to not include setup takedown time.
Okay, thank you.
All right. Thank you very much. Brandon, anything else you want to add?
I just want to point out one thing, and legal counsel might weigh in, but when it talks about a permanent development, the ORS 433 says, a permit issued here today does not entitle the organizer. So it's not that this permit won't permit. This is not a permit that issues a use for a permanent structure. It's the language is different. It says it doesn't entitle them, which could also mean that other permits couldn't allow it. They're not entitled. They're not allowed to have a permanent structure in conjunction with this. So it's kind of a technical term that's different than what was brought up earlier.
Thank you. So let me just say, first of all, again, thank you to everyone that's here that testified. Thank you for following the rules so well, for not clapping, for doing all the things I asked you to do at the beginning. I thought it was a very civil, as we talked about, public hearing, and so I do appreciate that, and for waiting 10, 11, 12, 3 hours and now 22 minutes from the beginning of this to the end. Secondly, I failed to mention this at the beginning, and I don't think I have to mention it to make it true, but there were a number of letters that were submitted today. Some of you actually brought letters and submitted them to the record. Some of you mentioned that you'd already submitted letters. That box over there is full. That's the record for this, that big box that we've been carting around the office. All of that information from the beginning is part of the record for this hearing, right? It all rolls forward. So if you testified before at the hearing where the hearings officer was, if you've sent letters at any point in the proceedings, that comes to us and we're able to review that. Also, I want to thank the proponents, and Ann, I know you didn't get a chance to finish your testimony, but from what I can tell from the testimony from the proponents, you run a very well-organized event, and that is not always the case when we have mass gatherings, and so I just want to thank you for the efforts, because I know it's not easy to do that. I have some comments in terms of the legal issues and the other land use issues that we're going through here, but I think I'll open it up to my fellow commissioners to, did you want to start, or?
I don't know where to start. I guess
I know you have notes, that's why.
No, I know what I'm going to say.
All right.
But I don't know whether we're at that point, are we, I guess?
Well, I think, and, yeah, I think we are at
All
that
right.
point.
So I'll just be the first to throw out, I'm not in favor. I would have taken and will take the staff recommendation. Brandon has some language changes. I thought from the very beginning, just a little bit of my thinking. First of all, I believe we have the authority under statute and ordinance in spite of what we've heard. Triggered by the numbers involved, if not the time, pretty clear on that. Overwhelming is protection of farmland, #1 industry. Farm practices trump the event. That one comment about Brownsville resonated. I was trying to make that distinction why it's different, and I know Brownsville. Family lives there, like a lot of places, John would say, but it's more one crop. And that we heard the diversity here in the Talbot area, so it's different. And I'm very concerned about impacts to traffic. I sincerely doubt the 30,000 estimate, and I think roadways are inadequate. I know of the roads, but you can see from the pictures, you can't get in. Related to roadways, I'm concerned about emergency management, public safety, both in terms of provision of those and the expense of providing it. So bottom line, I would take just what the recommendation says to dismiss the conditional use, deny mass gathering 17004, and the noise variant 17001, other than what Brandon says I need to accomplish the same thing.
Is that a motion?
So were you making a motion?
I guess I better make that my motion.
All right, so your motion is
Well,
to,
excuse me, could I hear from Brandon? You said something at the beginning that totally confused me.
Sorry.
But that's easy, don't.
Want to point out, if you think the county has the authority to conclude a conditional use with this permit, consider that the county maybe should deny the conditional use. The hearings officer reviewed the criteria for that. And a dismissal of the conditional use would be if the board thought the
So you
county
want it-
doesn't have the authority based on.
So the correct word is deny instead of dismiss, is that what you're telling me?
I believe so, yes.
All right, then I would make that my motion.
Thank you.
okay? So your motion is to close the public hearing,
Yes.
close the record, deny the mass gathering, noise variance, and conditional use. Option 2, is that what we're looking at?
I'm looking there, but it should be the same.
Yeah,
But it's not the same.
but it's not the same, so look at number 2. Are you good with that, Brandon, with number 2?
I think 2 is worded correctly.
Right.
All right, fine.
All right, so
The
that's his
motion is to
motion.
approve
Do we have
number
a
2.
second to that motion?
Yes, I'll second the motion, but I have some comments.
You may make your comments.
And the reason why I'm agreeing with the motion is that it's the way we are set up. And in the testimony that I heard, and I think you heard it over and over again from me, the concern that I have is what was different here versus there. And because we are looking at a conditional use permit, the testimony that impacts, and here's what I'll say, Marion County is the #1 ag producing county in the state of Oregon, and we have a cultural heritage that we need to preserve. And the impact, the potential impact, because a lot of it's speculative, I understand that, the potential impact to the agricultural production and the things that would happen in that particular area and the variety. We also have one of the biggest varieties of crops in Marion County as well. That's the conditional use issue that I didn't see we met the criteria because we are impacting EFU property potentially around there. The testimony on how well these things are run was positive. The testimony on the cooperation between the community, and we all know Jefferson is a really important asset in the economic potential that they would have. I wish that we could find a way around the conditional use issue, but I got to stand on the way we are set up in our code, that we have a conditional use issue here, and I don't see the testimony that I could approve a conditional use. I mean, I could approve a mass gathering permit, but not a conditional use permit, so that's where I'm
seconding the motion on.
Okay, thank you. So for me, on the mass gathering piece, the permanent structures, that was an interesting interpretation of the law. And Brandon, I think you spoke to that, that Mr. Reeder had, in terms of, it doesn't say you can't have a permanent structure when you have a mass gathering. It just says you can't use your permit for the mass gathering to get a permanent structure. But I'm not sure if that's like, splitting hairs in terms of how that applies to this. If there is a permit to have a well, and if it's in a sensitive groundwater overlay area, I'm not sure how that works. But even if the mass gathering permit is allowed, and I think it's possible that there's some wiggle room there, I do believe that our code, as currently constructed, does follow the statute, that it falls within the statute. There are opportunities for others that are at a higher level than us to weigh in on that and decide whether they agree or disagree on that.
Absolutely.
And that will be, my guess is that will be tested, and we'll find out whether that's true or not. But I will stand behind the code as it's constructed. And I believe that, given what we've heard today, that it actually exceeds the 120 hours and exceeds the 3,000 people, and therefore the land use impacts become relevant in the conversation, and the conditional use does become a requirement. I certainly appreciate and understand, as Commissioner Cameron said, the potential economic benefit to the area of Jefferson. We work closely with Jefferson. I've done a lot of work personally down there for many years around the overlap with Lynn County and social services down there, and there are many wonderful people that live there. But the arguments about how it's going to impact the farmers that are there were very compelling. The photographs of the large farm equipment, the discussion about how that's going to impact their farming, and agriculture is preeminent in our county. We say that continually. We have resolutions that say that we have upheld time after time after time. I thought it was interesting, the testimony that ODOT has approved the transportation mitigation. And so, people can argue about whether that's enough or not. I think that the testimony around the farming piece, perhaps you could argue it was not considered well. I also am very concerned about I-5, because I know that area, I have lived for 30 years in the Kubler Boulevard area, and I can tell you when there's an accident on I-5, it's almost always in those hills heading down from Kubler down towards Albany, and it backs up the freeway for miles. So that would be a concern of mine. The Brownsville piece did ring true to me too. My first teaching job was in Brownsville. Actually it was in Halsey, and I lived in Brownsville for a few months when I was back in, I won't even say what year it was. I think it was 1975 is when it was. So a long time ago, but an area that's near and dear to my heart. So I think based on the testimony that we've heard today around the farming impacts to the impacts to agriculture, and the concerns that I still have over transportation, despite the testimony we heard, that mitigation has been done, I'm finding that it has not met the requirements for us to approve the conditional use, and I will agree with the motion. So any further discussion? Yes, Jane.
I do have a point of clarification for the order or for the motion.
Mm-hmm.
Madam Chair, with respect to the hearings officer's findings on page 27, is it the board's position that it finds, as Brandon said, that under 433, the board does have the authority to grant a conditional use on this property?
Yes, we believe that the board does have the authority to grant the
Right.
conditional use, and that's why I said I stand behind our code the way that it is constructed. So that means that we have the opportunity to do 3,000 or the 120 hours and the conditional use being linked to it. And that's where I said that if that's not the case, it's not us that's going to figure that out. It's going to be someone on appeal that's going to tell us that it's not.
Right. I just want to clarify. So if you do adopt the hearings officer's recommendation, you would not be adopting her recommendation that you don't have the authority to find this, and you would be adopting her subsequent recommendation that if you find you do have the authority, that the conditional use permit criteria has not been met.
Correct, right. And generally, as I
clarification.
talked about that, that language is included in case the commissioners find the other way. So we don't usually, we just usually either find the one way and then just ignore all those conditions because we found that way or not. So that's how we've done it in the past. All right, any additional discussion? All right, we have a motion and a second. All in favor of the motion, say aye.
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 All right, that motion is approved. So that concludes our public hearing. Again, thank you all for being here, and we have no further business of the board. I've already read the calendar, and so we will adjourn.